tax, they ask you to pay about for 10 months, 10% rate of interest instead of 6% rate.
Yes, your lordships may kindly.
Instead of 6.10%, what difference does it make?
It will be going from the officers. That's the only thing. 96 para 10, your lordship. That's the only limited plea that I'm making before the court.
Paid.
Your lordship will pay it in from 4 weeks, but not from the pocket of the officer.
We are not inclined to interfere with the accused judge and leave the question of law. Regarding the first of all, we clarify it will be open to the petitioner to decide whether or not to recover the amount from the concerned officer after the undertaking is being inquiry.
Right. Your lordship may just stipulate an outer limit in which they can comply and inform the department that they have to pay within 4 weeks or 3 weeks, whatever it was.
You paid immediately.
I have told them, your lordships, but
Pay them immediately.
if it comes from your lordships, that is far greater pay.
Payment will be made immediately.
Very well.
Payment to the respondent will be made. The petitioner will now make payment to the respondent immediately.
I will pay. Grateful, your lordship.
This I may mark it before another bench. I don't know whether I had earlier accused from this matter. Or is that
Not to my recollection.
No, I
have not had in the case of before.
So the bench decided by Justice David Diwala, will commence it 3rd of March 2025.
Wait, please. Item 15.
Yes.
My lords, the High Court proceeds on the
So
15th.
tell us one thing. What is this voucher which you give?
Yes. Now, what happens, my lords? Exporters who are performing well are given money equivalent scrips by the DGFT. They are given the scripts under the foreign trade policy. For in this case, it's 2015-20. They are akin to money. So what happens, my lords, when
But then when you took out the circular, it was dealt with this purpose only. Was it not? The language of the circular is it's in terms of that only.
no, so it
But
is
we have one at least. The circular was to deal with this specific situation.
exactly. So what
So,
happened?
but then you should accept the circular.
So, sir,
Now why turning around now?
in fact,
Why reconsidering it?
they have followed the circular. And the
No, 1 minute.
I'll may just
Please, you're wrong. No, you're wrong on that.
Look at page 50.
yes, my lords, this
So it's worded. You grant an exemption.
correct. No, what
You
happened?
don't say that the duty will be paid by way of those
But
scripts.
my lords, we see page 50, the first line.
The exemption, that's what it
In
says.
this issue, no, 1 minute. This issue must have only arisen in case where the SSCs were using the scripts.
Yes, in this case, that's
And that's the reason why you issued the circular.
my lords.
So then when you issued the circular, you were conscious of the fact that some SSCs will be using the script and claiming there is no duty payable.
So, my lords, the script is equivalent to money. For example, 100 rupees duty is
Then you ought to have said that the duty will be payable by way of the scripts.
which
Which
is
is not what you said.
which is
You
what we are
said hereby exempts goods when imported against the duty credit script.
May I pass on a copy of the bill of entry? I have
No, please read that. Please read. The circular was very specific.
absolutely, my lords.
Your circular said, in case you use a script, zero duty is payable because of the use of the script. We will not collect the social development fee.
Because, my lords, the script is debited with the duty, therefore don't pay cash. That's the understanding of the circular.
But read your circular, page 50.
My lord is right. That's at first.
That's not how it's worded though. We seem to understand it now differently to suit your convenience.
Even the
No. It's the board itself taking a different view now.
SSC is
Going back on your promise.
when he imported the goods, they paid the money through the script, my lords.
We don't know if I could ground the case to interfere. We are not inclined to interfere with the accused judgment and its specific.
No, we went for a review. Against the review judgment is.
Okay. Later.
Whether a writ is maintainable against the award passed under the
That's
MLA.
pending.
And you are also saying,
Just tell us one thing, in this case, what was the dispute? But tell me one thing, why don't you go for 34?
No, it is time, but.
No, it's not like that. You have filed a first writ petition under 32 before this court. Turn to page number, your writ petition which is enclosed at page 89.
But your lordship has referred the matter to larger bench, Madam. In
I'm
Tamil.
aware of that, please, but please come to that. But otherwise, you will be under 34
Yes.
within the limitation period. Just come to that.
Yes.
Come to page 97.
Yes, ma'am.
The Supreme Court, there is no such similar pending, except CAP was withdrawn with liberty to file a petition on the same cause of action while order dated 1/4/2024. And thereafter, you file the petition before the High Court on 9/4/2024.
Yes, yes.
Correct? And what's the date of the award? Is October 2023.
Yes, ma'am.
What's the date of the award? 19th October.
Yes.
So if you exclude this period in terms of section 14,
Yes, ma'am.
will you not be within limitation?
But the
On
problem,
when
yes,
Mr. Sanghi, let's be very clear.
yes, ma'am.
Even if we say that writ petition is maintainable, it will be maintainable only in few circumstances,
Yes, ma'am.
not in all cases. It will not be the same merit review, or even the scope of review will not be same as in 34.
Yes, ma'am. But I have to deposit 75%.
Yes, you are right, but please examine one thing, in a writ petition,
Yes.
your review, because in this case,
Yes, ma'am.
what, if you go through the award, you virtually accept everything,
Yes, ma'am.
or merit you accept everything.
I will examine, madam. There are two more connected matters, madam, pending. I will get it listed.
On paper,
Not much, madam, but 2 lakhs, 3 lakhs.
2 lakhs and 3 lakhs of rupees, then you go because
Madam, there are number of, this is not the only writ petition, madam. There are 2 more petitions
how
connected.
much the total amount?
I will have to check. In other cases, I will have to check the amount.
Is it just 2-3 lakhs of rupees, then why should we show it when you have the adequate remedy, you can go under 34, 914.
I'll check up and, because there are other 2 connected matters.
Otherwise, you are right, we have kept the issue pending, but it will not be an open-ended thing. The petition will not be equivalent to open-ended thing.
Yes,
It will be only in the grounds on which petition can be entertained when there is alternative remedy. In a special case, because it's statutory arbitration.
yes.
It is not an option, and we have come across cases where there's some wrong orders have been passed by the council. You want us to attach it with other one, we can do it.
Other 2, I said,
Bro, we'll keep it afterwards.
yes, ma'am.
We'll keep it, that matter be decided. Delist, and the request of ask for the petitioner delist in the week commencing 24th of April, 28th of April 2024. That's 2025.
Please. Manoj, paragraph 5, the High Court says that we have issued beyond 4 years. We have
Should
issued,
not complete the examination of state facts.
we issued within 4 years in this.
Maybe, but states, you can't reopen on the same facts.
No, but the subsequent tangible material being the SAT order, Manoj.
No, please, sorry,
With the
sorry,
time of exam.
sorry, to fix the payment. You could have delivered without the SAT order done it. That's not tangible material. You could have, he explained you that I made a mistake, I did not pay that amount. And later on, I made a mistake, so therefore he said this is lost money. Don't make that. Just a year of when the deduction is to be allowed or expenditure is to be allowed. That's the issue. We are we are not inclined to interfere with the accused judgment, especially remains in their control.
May I please, Your Lordships, the question of law that arises in this petition, Lordships, is it lawful and correct to saddle the petitioner
You are the petitioner, you're lucky.
Lordships, I have been intimating time and again by way
No, there are two things. You could have, there's a bank which should be agreed by the sort.
Lordships, as a matter of fact, my lords,
You are, one thing is, there are two things. Under the law of pledge, which will be equally applicable to mortgage, a borrower cannot insist that the pledge receipt should be sold. He cannot insist. Same principle will apply to mortgage. Same principle will apply to mortgage because you have to pay the money. You could have asked for the buyer for that money.
execution proceedings may be expedited, my lord.
In fact, let me put it very clearly. It's a bank should be agreed by reduction from 10% to 6.5. Not you.
I leave to you, Lordships. Thank you.
The wrong day. And to interfere with the impugn judgment and has specially petitions dismissed. We have clarified dismissal of the special petition will have no bearing on the petition if any filed by the respondent.
Well, in item 19, the order seems to be very innocuous because the only difficulty is this. So far as my representation is concerned, that has been authorized by the bank.
Look, let me put it. People don't realize OTS are only accepted. When are OTS accepted? They are only accepted when the offer made by you is more than the value of the mortgage property. If the offer made by you is less than the value of the mortgage property, OTS is not accepted.
No, what I am saying is, as far as the OTS has been proposed only because there was a mega OTS scam that was held by the bank, in which minus this was the offer which they has come from them. What? Lordships? May I because this, so far as the representation is concerned, that was the High Court. Lordships, kindly, the only thing I am asking is this, minus. The High Court has said.
Can't ask for anything. Can't ask for anything. Let the auction take place, you buy it out there.
Lordships may then say one thing, at least the bank may dispose of my representation.
No, they have rejected your representation. Not once you say letter is not received. Very difficult to accept also. We are not entitled to interfere with the appeal judgment and especially with the systems.
The impugn order says that you have an alternative remedy. And Madam, what do I do?
What you do, you sit at home,
I keep
pay
writing.
the penalty there.
I keep writing.
No, you keep on writing, that's late experience.
Inspection report.
No.
Please.
No, doesn't make a difference.
Please.
Doesn't make a difference.
Cross is not permitted. But may I have this? Madam, may I have this face?
You did not, you know,
I repeatedly write to him and
this is all nothing doing.
no, Madam, may I have this inspection? What reply will I find?
You-
have not given the inspection report. I am not given the
You file whatever, we don't have to tell you that.
reply without him.
Sorry, miss.
Without a seizure. and-
Sorry, not required. Just, your conduct speaks volumes. Your conduct speaks volumes. File an appeal, file an appeal.
Categorically say
File an appeal, Mr. Kaur.
deposit.
Yes, 20%, that's all, 10% or 20%. No, sorry, Mr. Kaur, it was 20%.
That alternative remedy is not a self-imposed restriction, but in a matter where there's a violation.
Mr. Kaur, if you want, we'll reiterate this is a case where you are marking time deliberately, not answering. No, Mr. Kaur, the show cause notice is so detailed, going to 200 pages plus,
But they have a respect only.
speaks volumes of your conduct.
Nothing would be Roger's commitment to withdraw with liberty to file the appeal and just give me some time to file the appeal. It should not be time barred. That's all that I'm saying.
Move an application for connection of
That's what Roger can say. That's what can say, my lord.
After some hearing, when the court was not inclined, that
Don't say that. Say that I've been wrong. Please don't say that. Don't finish my opinion.
okay, right now, well, senior advocate for the petitioner seeks permission to withdraw its special petition. The petitioner says the petitioner will file an appeal in 3 weeks from today. So he submits that the appeal is filed in the same period may not be discussed on the ground of limitation. Next week. The petition is discussed, the special petition is discussed in the law, the remedy is paid for. If any application for confirmation of delay is filed, the same would be considered sympathetically and according to the law.
I'm very grateful. Excuse me.
Well, see, there were 2 petitions. One is not listed today.
Any order in that,
There are different facts I'll point out. It's not
when it comes up, but one thing is very clear. This non-filing of reply, the show cause notices issued by the Customs and Excise normally are very detailed. And this is again very detailed. It's not a short show cause notice. It's not like the income tax department. 148.
Only one state.
Sorry.
Only one statement.
And normally, the order is passed almost 2 years after the show cause notice.
Well, they gave the time themselves after the order passed. I'll plead in my case.
Grateful.
Your Lordship's order is at page 57.
You are paying for the respondent.
He's connected online.
No, who's appearing for the respondents?
We are, Your Lordship. I'm being led by Mr. Bali. Please.
Okay, let him connect.
Manoj, I will only say one thing. Had the respondents put us on notice, we would have saved a lot of time of the court. In fact, facts are. Just one second. Notice means a legal notice, but everything is rectified. Mr. Soni will just hand over the relevant documents to your lordships. You would have told them that, just a minute, sir, whatever they require has already been done. And we have done more than that, Manoj. Just kindly have one by one that. So we should not be wasting your lordship's time, and we have totally abided by my lord's order, and there is no question that we will not abide by it. But the petitioner's name is NIFD Institute of Fashion Designing Limited. Their logo was INIFD Cradle of Designers. Now, Mallards passed the order on the next day itself. Mallards, I changed my logo.
Okay,
in terms of,
if you have done
yes,
it, fine. Now release.
I've done it. No. Further, sorry. My learned friend will allow me to speak. This is not only what I have done. Now he says, just a second, sir, allow me to speak. He says that I have not changed my website, but I have changed my website. Mr. Soni, can you hand over the change of the website to my lords?
Website is
I have changed. Just 1 second, sir. I have changed my email.
Compilation that I have just handed.
Then he says, I have gone to Pune, I have gone to Ahmedabad, the billboard signs of the franchise are shut, just showing NIFD. But there was a delay of 10 to 15 days by my franchises. I had informed them, everything is changed.
I will see 3rd of February.
Everything is changed.
Fine, now it's changed it now. These are
Yes,
basics. In this case, by the execution.
So had he told us, my lord,
We have already moved 39.3A.
yes, exactly. That's what I'm saying.
39.3A. Probably even on 39.3A, they were not.
Absolutely.
Next, Mr. Bali, let me put it.
Yes.
Intention of not being put to notice does not merit consideration because he's filed 39.3A.
Yes. But we have answered it there also. We would have answered him. And we would have called him for a cup of tea and asked him, what else you require me doing?
That's not your life and
No. We had already done it, my lord.
High Court.
Right.
Of your Lordship.
We have done the needful.
Let me see an educator waiting on behalf of response states that rectification and corrections have been made. And the response are fully compliant with the directions given with the order dated 4th of October 2024.
Your Lordship may clarify this.
In view of the aforesaid position, the present contained petition is disposed of with liberty to file a fresh petition after due notice to the respondent. In case he finds his violation of the
Lordship may record the statement that they will use the expression NIF. This is what the option is.
Yes, we have given.
Yeah, that's what we are using already.
Option.
Grateful. Deeply obliged. I'm grateful to your lordships.
Lordship, as for the office report, a second petition which is reserved for order raises the identical question. Farmers of the board could levy the environmental compensation.
Pardon?
But if they, as per office report, two cases has been cited. First case is different because that is regarding the power of NGT to impose environmental compensation express builder. The second case is identically similar. The question involved is whether DPCC can impose the environmental compensation under 33A or 21A of WARE. This is same.
That's, the judgment is reserved in that case.
It is reserved. But just in a similar.
In order to review the submission made by the senior counsel for the pollution control board, the next after 4 weeks. Still pending? The High Court proceedings are still pending?
It is final order. They have allowed.
It's a final order.
Issue on the basis of entry.
Issue of office returnable. I thought they are still pending.
This is final order.
Issue of office returnable in the week commencing 28th of April 2025. It's left down, including last week. It is submitted at the impugn judge. They are getting the impugn judge requires consideration. So it was pointed out several matters are pending and in back with one case,
There is a delay of 15 days.
Next case.
Yes, please.
Yes, please.
The issue on finding on possession, that is.
1 minute, please. Look, there is a debate. Let me put it. It does appear that you were given possession. The possession after they took over the possession. They did give you a possession.
Allow me to exhibit on that.
That saying that we allow them to vote 3 parties is all wrong because payment is also made by you. To that extent, there is a filing against you by the court. It is not correct because it appears 22nd May they took possession. They then allowed you to re-enter and then in September they dispossessed you. That's why you've taken off the newspaper articles are quite there. July you also had waiting.
So
but otherwise you are in default.
On that issue of possession, does my reading convey the message that I am not in possession? That was to be seen.
Then you are in default of period of
This is a disputed question.
But
The court was incumbent to appoint a.
no, I'm saying in your favor, why not?
I'm so sorry.
I'm rejecting their plea that and the finding in the order. That's wrong. That's it. That's odd. So you paid the money, you held the weddings in July, that means you entered the position and the photographs clearly show that you were dispossessed in September.
Grateful.
That is in your favor, why you objecting?
I'm so sorry.
That plea of theirs is a make-believe. It is a case where you are dispossessed, they put the locks without taking permission of the court, they themselves put the locks and they threw you out. But then probably when you paid up the amount, they allowed you to re-enter and then they took it back in September. But you have been at fault, you are not.
That fault has to be decided by the arbitration. These are all questions.
But section 9 will not.
Arbitration.
Then section 9 should not have been invoked. What is the state of arbitration now?
But arbitration has been invoked. The proceedings have to be started. Now I am going to file a proceeding.
You will not file your claim.
Not yet. But the problem which is arising in this matter, there was a fit out period of 7 months.
file an application for arbitration.
Yes, sir. I've already appointed Mr. Rafiq. One Mr. Rafiq has been appointed as
Mr. Paul, let me put it, the story of yours that you just allowed him to hold the weddings for three weddings and he did not really deliver the position is wrong. That finding is wrong.
His own pleadings say that he was dispossessed.
Yes, he says on 22nd, but you allowed him to
not dispossessed.
Under the consent permits.
No, you took law in your hands. You took law in your hands by putting the law.
Your lordship have time and again said that as far as the licensee is
No, it's his own license. Why did it? Mr. Paul, this is not a license. He's getting.
license. Then what is this is a lease? Well, this is not a lease. His own rights are of a licensee under the Easements Act.
You may be calling yourself, you may be calling your.
This case has never been that this is a lease, not a license. In a license, my lord, some contract.
We are going to observe the findings recorded in this order will not come in the way of the arbitration.
Totally, this is one position. I have spent around 25 crores in the property. There was a fit out period of.
I know, this license went inside, or it's been a charge. Again, somebody is absolutely a charge.
So they argue that SLT and new cases
over the property.
Right up. We are not
SLP is now
inclined to interfere with the accused judgment in view of the peculiar facts of this case as in view of the fact that we are not inclined to interfere with the accused judgment and especially petitioners discussed. However, we must observe that some of the findings the findings recorded in the accused judgment would not be binding on the arbitral tribunal, which will re-examine the whole issue of fish without being influenced.
It's not interested.
Without being influenced by the observation.
Great. Lord may provide a status quo till the guiding my practice.
No. We need
Entered.
one minute.
Destroying my item.
No, it may be contrary to your interest. Because the moment status quo is there, your claim for damages may go down.
Yes. Grateful.
You have a good case for that.
Grateful.
But I believe the High Court, I'm sure your lordships have seen the charges.
So notice, returning. Please accept notice. No, please, we'll have to take them.
Because there should be a stay away. He's accepting notice.
Okay. Issue notice returnable in the week commencing 28th of April 2025. Notice accepted by respondent. Second Singh is present in person. That accepts notice. This one. To supply maybe 4 weeks. We join within 3 weeks after service of reply. Original records will be produced in the court on the next date of it. There will be stay of operation of the appeal chapter in the next date of it.
I'm okay.
R4, the service of notice will be issued to respondent number 2 on steps to be taken within 10 days. Notice will be served by all at once. Yes, please.
Teacher, on the 25 is a case where I had challenged my 80 AR because
I know, but after how long will you challenge that?
because this was never clear.
No, this is a sharp. After the judges of the school. The start to judgment.
Please, Roger, that was 2009.
After that they have been doing it.
Please, Roger, to see, but they were not able to produce any proof before the law. If
Same year you got the reward or is
I got 2 rewards.
in the same year you got the reward? Issue notice returned in the week commencing 28th of April 2025. Notes to be served by our courts including the state. It is submitted that the awards given forward for the same year in which the grading was, the award of best year is for the same year in which the amount grading of the petitioner was downgraded. The response have also not been able to produce any material to show that downgrading was communicated to the petitioner.
in fact, the reporting officer had given me very good.
No, I know, we have understood that, but the very fact that you have the papers will indicate that you are aware of the grading is.
No, that I became aware.
Kind of 22. Because normally what is happening is after Justice Karchu's judgment, and some parts of the country, my brother was saying some parts of the country it's not being followed, some other parts of the country they started complying with it because Abhijit came thereafter. Abhijit reiterated that view, and there were then issues that I think Department of Personnel had issued also instructions.
Please, Roger, because what they're doing in CAPF is that when they communicate the APR, they take acknowledgement and that they file in the APAR file of the employee, which was also missing.
They still say because they have after 5 years they have weeded out the file. That's what they're trying to.
No, that they have weeded out the official record,
But you must have got your receipt after 1 year.
No, yes, Roger, I got after that period of 5 years got over.
5 years or 1 year?
5 years.
Next case.
Your Lordships, this is a case in which a blacklisted party.
No, blacklisted is fine.
Your Lordships, no. Your Lordships, it was from 20 to 23 was one.
The two aspects. When was the blacklisting order passed?
Yeah, it was in August of 2020. I just
August of
2020,
and it was valid from which period to which period?
It was for a period of 3 years, Your Lordships. It was for a period
10th August
2020 to 9th August 2020.
9th August. When was the date of notice?
Your Lordships, this particular tender was floated on 16th of October 2024.
16th of October
2024.
Now there are two ways to look at it. One is when we refer to anything blacklisting in the last 3 years, we can refer to the date of the order.
Yes. And
that date of the order is beyond 3 years.
that is one. But yet,
He did not disclose it.
yes.
As far as the department is concerned, they were also not aware of it.
They were not aware of it, in which
1 minute, please. Who got the contract ultimately? R5 got the contract.
R5 got the contract ultimately.
And number one, you are not the lowest bidder.
I was the second. I was the second highest, Your Lordship. Next.
You're the right one, or there was somebody else in between.
I was the second. There were only 3 parties who were finally identified.
There are 2 ways to interpret. One is that the order was passed in 2020. If the order is passed in 2020, the bar of 3 years will not apply because the data was voted and given is in 2024. The person is entitled to interpret the clause as it is no beneficial to him. You know it. Only that lawyers also do it.
Lordships, to which I only add on to state that it was not even the manufacturer of the tendered product. Lordships, to which I only add on to state that it was not even the manufacturer of the tendered product. The second important point is it is not even the manufacturer of the tendered product.
That's their means.
But Your Lordships, what is to be considered is that as far as SANJIV is concerned, in their reply itself at page 144, they have conceded to this position that they have not been verified this fact. Because my respect
Now the contract is awarded.
And Your Lordships, also one more important issue which I will point out that are being rejected also on a hyper-technical ground by the High Court. It has not dismissed me on this ground. They are only saying that you have no local standard.
No, then we're not going.
Which Your Lordships, my respectful submission is that there are public safety issues which are involved. These are conveyor belts.
Oh, they conveyor belts.
The person was not even a manufacturer.
Most of the manufacturers
And it is arbitrary, Your Lordships. They are importing the products. That was our thing. It is going to be dangerous.
Right, because there was a huge starting and a special decision.
May I take the lordship, my lord?
Yes, please.
One respectful submission, my lord. This is an MSME, my lord. It is very, very difficult, my lord, to even survive in that state, my lord. What has happened is, may I just show one submission, my lord?
We've been asked to deposit 50.
Correct, my lord. I was finding it difficult to deposit 50. May I just show one, my lord, only one legal argument, my lord. Your lordship sees, my lord, this honorable court has upheld the RBI master certificate.
We are aware, but that ultimately you don't realize that in result of dismissal.
No, all I'm saying is this, I want to pay. My lord, today, please, just one page, my lord.
You have been in default for very long.
See page 22, my lord, just one page.
You have been in default for
No,
very long.
but please see page 22, my lord. My lord, my only prayer is this, I need some time, my lord.
50% only you have been asked to deposit, not to put.
My lord, I'm only saying this, please see page 22, my lord, just one page, only one page, my lord.
Sorry, please, since when is it default?
My lord, I set up this MSME in 2014. The bank advanced 2 crores to me in 2019, my lord. There has been a default, my lord. I'm not running away. I'm only saying every scrap of property that I have, my lord, is attached. I'm trying to, my lord, the other funds, my lord, to pay. My lord, please give me some time and reduce, my lord. Lord, because Lord, this is a very fledgling, my lord, industry. Trying to, my lord, back it up, my lord.
We do not fight in good ground.
Your lordship's kindly consider, my lord, extending, my lord.
Please. We do not fight.
Even if residential house,
Maybe please.
everything is
Nothing has come from 2019 onwards. Not a penny.
paid. It's
Not
not
a penny. Nothing, 50%. The amount was 2 crores and not. Today it's 3 plus something.
It's 3 crores today, my lord. It's 3 crores today.
We are not inclined to
Requesting
give them
sympathy.
government and then special petitions.
Very
Next.
good for that.
Please, my lords.
Yes, please.
Lord, this is with respect to the cancellation, lords, the grant of bail.
Yes, sir. Okay. Are you married?
No, lords.
You're not married?
No, lords. The child is from this very relation only, my lord.
No. But are you married otherwise?
I'm not married.
Your father seems to claim that you were married.
No, lords, I'm not married, lords. That the.
No. Are you otherwise married?
No, I'm not married.
You're single.
Yes, my lord.
But as far as she claims that when the father sector came there, that you already married.
No, I can put an affidavit to that index also.
Just come to page 25.
Yes, my lord.
It says the father of accused stated that accused is already married.
The accused is married, not. I'm the complainant.
So
I'm the complainant, not the accused is married.
Please come to page 3.
Please, my lord.
The extracted order refers to your affidavit, which, according to the High Court, falsifies your claim that you were not aware of his marriage. So he was married before he got into the relationship with you.
Not subsequently, when I was in the
You have not filed a copy of this affidavit. Whatever affidavit you
that he preferred in the Miller's anticipating, he himself is not placed, not consider one aspect, Miller's. He had offered to.
Relationship for too long. You had a child and also.
Because that is on this relationship.
I know that. I understand.
No,
I understand that, but the factor is that you never got married, and it does appear that you already aware.
No, Milords, it's subsequent. When I insisted to get married, Milords,
cannot be.
Now, Milords only considered one aspect, Milords. Now, there is a child with me, he had offered to pay some sort of money. Milords only considered that aspect because I have to take care of that very child. Only that limited point, Lordship may consider that aspect because there is a girl now she's 7-8 years now. So he himself offered that money, but High Court has not considered that very aspect. He himself offered.
You go for the compensation of bail, you can go for under the 125, etc. You get your money.
Because then again, if Lordship may, in this itself, because High Court would have considered now. That's the only limit.
You're not inclined to interfere with the accused judgment, but leave it open to the petitioner to take recourse to appropriate remedy in case with appropriate remedy for payment of expenses, etc. Payable to the child.
I'm grateful, Lord. Lord, I was part of there was some delay in refiling this matter. Grateful, Lord.
The question was whether or not employees of the integrated coach factory are public servants.
The distribution of the state, there is no occasion for sanctions. They are not public servants within the meaning of 1987. It is a judgment of this honorable.
They will not be public servants.
May I show that?
No, but the reason they are given for not giving sanction is something different. They're saying that otherwise they are not responsible. They are not responsible for it. They are not responsible.
In fact, sanction appeal of the High Court.
No. They have said that they are not responsible, and therefore they are not saying that 197 will not apply. Don't they are conflicting language on this point? They are conflicting language on this point of when sanction is required.
Is statute like that?
Madam, I'm appealing on behalf of Railway. We have filed a report. My lord has given us direction to submit a report whether sanction is given or not. So we have submitted. We have not accorded sanction because the problem was not their intentional the systemic failure. Due to that such incident happened. So Railway Board has denied sanction for it. So this is
right up. As we have to be taken up for regularly and connection. Then the top into 2025. This issue will require to be considered because the conflicting values in the sport. When you say that the standard was the usage within the course of the sport or outside the course of the sport. In any case, this case, it was at in the factory itself.
Arts and legal contractors have specifically liability is on the manager and the occupier. 92 days.
The fee for suspension of sentence.
That was 1 year, 11 months now, since March 2020.
We've seen the evidence. The father, accepts, everybody accepts that she did not take the money and we made a false statement that she did.
That so far as money is concerned, but so far as rate is concerned,
Please, one minute please. Because the only question is not whether it's a statutory rape or not, because she was less than 18.
Please, madam.
And she became 18 within 1 month or 2 months thereafter. And the question of, I don't find the evidence on the age of the girl. Where is that evidence?
Page 21, madam.
What is that?
The mark sheet is there, my lords, and your lordship on the.
No, that's not binding. That's not binding.
My lords, on the last petition, your lordship sees, your lordship wanted to see those judgments which say that juvenile justice act, whether it will apply or not, madam. There are 4 judgments as recent as 20.
No, please, there is a difference between the inquiry, which is, if you read just Nagaratna's judgment, and you read just Pradivala's judgment. It's very clear. No, please, it's clear. It's very clear. As it's just Nagaratna's judgment, it draws a distinction between the standard of proof, where it is before the board, and when it is before the court.
So, my lords, the standard of proof may be.
No, please. So, for one month or something, 2 months, sometimes. It's a case of consent. It's a case of consent.
Because there's no question of consent, madam. It's statutory rape, madam.
I know that, but the question of age will be the issue. Right up. With regard to the facts and circumstances of the case, we feel that the appellate that was already undergone consideration for more than 1 year and
11 months.
11 months. Should be released on suspension of sentence during pendency of the appeal, which is pending before the Rajasthan High Court, and it's likely to take a long time before it is heard. And which cannot be heard within a reasonable time. So, we allow the person to that the appellate probing will be release or suspension of the of general SP Criminal Appeal number 792 of 2023 on terms and conditions to be fixed by the trial court.
It's not going to do it. And the judgment was pronounced, we didn't turn up. So that's clear.
The petitioner, the applicant will get the mobile telephone number, which he can be contacted by police or the police officer.
It is already seized by them. I'll have to take a new number now because I've been inside for 1 year. Then.
Look, my brother tells me I didn't notice that fact. We have recorded.
For some time, madam. He was also minus 20 years of age. Lordship
was 20 years old.
But 2 years now he has been inside. Under 342, etc., he has already served the incarceration of minus 1 year.
No, but other offenses 10 years.
Others. For that only, madam. Wait.
This is very strange, mother. That the sister then, after getting all the releases, after we having paid 75%, mother, sister goes and files a suit and says that, look, there is a family dispute and therefore all these resolutions are bad. They are living in the same house, mother. The sister-in-law, they are living in the same house. And the notice they say is sent in Calcutta. This is all collusive to deprive me of mother of property for which I got part possession under 53A. They are running a factory there.
No, but the appeal has been discussed.
Yeah. On what ground, mother? On the ground, this is all completely wrong. It's not even discussed.
The partition suit?
Nothing that's still going on with it.
Sir, this property is excluded from the partition suit. They have filed a suit for a specific performance.
That's right.
It is pending. And one more thing, they have also filed a criminal complaint against a director with whom they have entered into this agreement. Those directors have been prosecuted.
Yeah.
Now, we have been totally excluded. They have colluded with only one director, entered into this so-called agreement to sell, and they have.
What's the date of agreement to sell?
The date of agreement.
No agreement to sale is registered. The sale deed not executed. And that sale is registered, mother.
Makes no difference. Let it be. Let it cut.
2011.
30th of March 2011.
Who's in possession of that property?
Yeah.
They are in possession, not the day one they entered into the agreement, they have been put into possession by the director who has been ruling the roost mirror. Only one person was running the affairs of the company mirror. No resolution mirror at all.
Was staying with them earlier.
Sorry?
They were staying with other directors earlier.
Yes, the same house. The sister-in-law is in the same house. And she said the notice was sent in, obviously, because they got their bank, they were to give bank guarantees to the bank, they got them released.
They had also given the sisters.
Yes, they got them released.
The sisters had also given bank guarantees.
Yes, but we have also given.
But also bank guarantees released.
Yes.
And how will we not be aware of that?
Can you see?
Somebody must have paid the money.
The moment I had come to the knowledge of this agreement, I protested, I wrote to the bank, all these are part of
the payment has been made pursuant to the agreement to sell.
But to the bank, not to anyone else.
When did you file the petition?
I filed it, my lord, immediately after coming to know.
When did you file? I want the date. You say I filed it.
20th March, they filed for operation and mismatch.
When did you file it?
20th March 2011, they filed for operation.
When did you purchase the property?
The registered agreement was, payment was made in March, last payment. 30th March.
March 2011.
They filed in April 2011.
April 2011 they filed it.
Yes.
Yes.
And the resolution to sell the property is in March.
The moment I
But
to know that they are.
that's how they got their bank guarantees released, brothers. In the resolutions.
Participate in the board resolutions.
Not at all,
Because you said that all.
But that's in no management, that's their problem.
No, Mr. Debel, the sale of the agreement to sell is March, they filed the petition in April.
They got the bank released.
No.
Yes, they were challenging that
that shows that they were voting in dark.
The concept of window management is quite clear.
No, window management is not applied.
I'm sorry. Why would it not apply?
I can tell you the reason.
Yes.
You are fully aware who are the directors, you are knowing that is the price.
How am I?
Not very risk. Nobody buys property like that.
I'm sorry.
Nobody buys property like that.
I'm sorry.
Property is owned by the company.
I paid the bank. I paid 75%.
You have a cause against the brother?
They got the bank guarantee released. How did they get it released?
The brother was a partner.
There is an EGM. I'm sorry, Manoj.
In the EGM also they never participated.
They have got 0.1 percentage, 0.3%.
How much is their shareholding?
10%.
It's more than 10%.
Okay, settle it out with them. Pay. Settle it out with them. They have 90% is better brother?
Yeah. And other shareholders.
No, who are the other shareholders?
Family members. And they're all voted.
And how much is the shareholding of the brother? Others have all voted? Others have all voted?
3%. Others voted in the resolution.
So we had only one director. As a matter of fact, nothing had
Let
happened.
him explain. How many voted in your favor?
90% for resolution. 90%.
90% voted in your favor. No, 90% have voted and there is no dispute on that. Is it factually correct that 90%?
EOGM had never taken place.
But I'm asking the question and I have to answer. I ask it, this is something very strange. You don't ask the question, you don't answer that, you go on a different direction. Please answer the question. Is it factually correct that 90% of the shareholders have voted in favor?
No.
What in the EGM, how many shareholders participate?
What my case is this, no AGM had taken place.
1 minute please. Others have not questioned the EGM. How many shareholders are there?
4 groups are there.
4 groups.
Groups belong to me.
1 minute please. What is your shareholding?
My shareholding comes to 10.91.
Very important. Other two groups are not objecting to the EGM. Are the other two groups objecting to the EGM, not objecting to the EGM? Are the other groups objecting to the
Saying objecting because they were, as a matter of fact, there were 4 directors.
We are asking, are the others objecting or not objecting to the EGM?
They were not objecting because they were
directing. Mr. Simple, sit down with them. I pay them. The question of money. Right now. So, is your party there?
Yes.
And your party can, you want to go for mediation, but you're open to mediation. You're lost twice. You're hanging by a very.
You can go for mediation, there is no reason.
Right. Conversation with the court that does the practice saying that they actually store possibilities of the mediation. Every parties will be able to work mediator. One. 20th of February 2025, just before the court is recommencing. 5th of May 2025. Okay.
Tito, I'm appearing for respondent 7. I'm seeking some lines paid after notice. I'm appearing for respondent 7, Department of Irrigation and Flood.
All in this, the doctor is calling me not have survey.
No. I have nothing to say on that, but I only want to place on record how much work has been done, at what speed it is going on.
Will restore the backup, send it back to the High Court. Or is rules of the petitioner?
Yes, Lord.
Is there work going on there, Mr. Yadav?
Lord, rest in most of the part, the work has been completed in 17 and 22 and 25 also, Lord. But they have left only 2 roads near my house, Lord. It has made the payment.
Give me 2 weeks time to place my reply on record because it is incorrect. But the work in the irregular colony is going on. It's almost complete like that.
Okay, about it. Then we record your statement. Regardless of the fact that Sri Sports Colony is doing the work of sewage and water supply and is likely to be completed as soon as this.
Regarding the 2 streets that my friend is talking about, this comes outside the approved map of that colony. He says that it has now been registered by the DDA. The DDA is, we work under the Ministry of Urban Development on the approved maps. These 2 streets are outside instruction.
No. Lord, this is not correct, my Lord. They have laid the water pipeline, my Lord. They.
At the request of Councillor Bengal, Senior Advocate of Bengal, self-respondent. Phase 1 is granted 3 weeks time to fill instructions. Release in the week of essay 28th of April 2025.
This street has not been issued.
Which one? 33 issued. 32. Huh? For condemnation of delay is allowed, and notice will be issued to the applicants and to respondents.
The Johnson item number 33 bank members R2 and R3 are yet to be served.
Respondent number 2 and 3 are not served. Issue fresh notice to proceed and serve response to steps being taken. So this notice will be served on. You are paying for
For the state here, Lordship.
You have to file the on-credit plan or you want to argue without the plan?
We want to argue the matter.
Without?
We can file the, we will file the counter affidavit.
Take over. Prashad is represented and they file the plan. There's 3 weeks. Because it is anyway 2 weeks after service. This is the week of 38th of April 2025.
Yes.
38th of April. March.
Yes, please.
Before the High Court.
Second part. Eight, six. Password.
Your Lordship, Your Lordship, we are entering Mr. Dewan in this matter. We expect for a password. Right.
120 days, your lordships have laid down, that's being followed. Absolutely no reason, my lord.
Proceedings are.
Now, so it is listed today, my lord, for 39(1) and 2 to be considered.
What is the suit for?
It's a suit for specific performance, my lord. It's before the Commercial Code, it's under the Commercial Codes Act. No objection in regard to that aspect is ever been taken. Being proceeded, they contest right from January, but they have to file their written statement only in November.
High Court. It's not your purpose if you initiate notice going to delay or matter.
My request would therefore be, let the
Look, even if right to file the statement is taken away, they can still question you on the cross-examination.
Yes, let them.
They can question you in cross-examination.
Yes.
So for specific performance cannot be taken without evidence.
There is actually a method to why they have done this. Between their entering appearance and finally filing their written statement, they have created a number of third-party rights of the land. That is why my 39(1) and 2 are impressive.
Sure, what is determinable, let's say, 28th of April, 28, 20, we commencing 21st of April 2025. Notice will be served are almost including trustee. It is submitted. And the written statement could not have been taken into court, as the proceedings are governed by the Commercial Codes Act. Stop. The next last based on the judgment in the case of Kailash versus Sanjay and others 2005, 4 versus 418. Stop. Should we stay the proceedings?
If your lordship could stay the proceedings, but clarify that the 39(1) and 2 could be heard. Because I tell your lordship why he is continuously creating third-party rights. Making plots space.
Right. In the meanwhile, there will be stay of proceedings. However, the application and the interim application is very vague, can be decided by the trial court.
I'm ready.
And there will be stay of trial.
Please, once.
That's the possibility.
You are appearing for the petitioners in item 36 months?
Yes.
Please, once. It's in terms of
Also, matters coming up on the 19th of February.
Circumstances have
But do I not also see the film?
we've
So you have only seen the trailer.
only seen that. Trailer itself.
No, we don't know what exactly is. Then come up on 19th, then it's up. Then come up on 19th, then it's up. If it is need, then come back. As the matter is still pending before the High Court. As this from 19th to 2025. We are not inclined to issue notice in this association condition. So, however, the petition is given to the people of this court is being notified.
It was clear that some guidance from an earlier bench, earlier order which has been passed by this court, which essentially did two things. It's allowed intervention on the question of law and restricted the oral submissions to appropriate time limit. So I am requesting something similar in our case as well. Your Lordship may go to the operative directions which are contained in paragraph 12, and then I'll come back.
Yes.
Bearing in mind the facts and outcome of the appeal would bear upon the claim of the appellant, we have to consider to that the following order would meet the ends of justice. The request made by the appellant for impediment is declined. Appellant is granted liberty to intervene in the appeal by urging such submissions on law as the appellant seeks to urge in support of the appeal which has been filed by the first respondent. We record the assurance of senior counsel appearing on behalf of the appellant will confine arguments to no more than 30 minutes. No adjournment shall be sought.
Why should they do that?
Yes, so I'll tell you why. Because the issue over here, this order appears to be incorrect according to us for two reasons. One is, we are representing all insofar as the solar power generators are concerned. Now the problem over here is that the CERC has made a determination which will have an impact across the industry. So they made the determination in the case of the appellant before the appel, which is fine. But if that gets crystallized before the appel, then it will become a norm across the industry. Now there is a very important issue which I just explained to the court over here. As your Lordship knows that if there is a change in law, the generator is entitled to recompense to the distribution company. Now here there is a change in law, so there is no problem on any of that. Now the DISCOMs came up before the Electricity Regulatory Commission and said that a one-time payment for change in law is becoming extremely harsh. So therefore, please stagger it over a period of 13 years. So the CRC and the generators have accepted that. Now it comes to the issue of what is the rate of annuity. So the rate of annuity, as your Lordships will see by the CRC, is 10.41%. And that has been computed having regard to the debt of the investment in the project. Now, debt is 70%, equity is 30%. Our primary contention in the question of law which we want to project before the appel is that this is an improper manner of computing the annuity disregarding the equity component. So that's the technical issue on which we wish to make submission. And your Lordship may confine us. I have in fact taken instruction that oral submission will be confined to 15 minutes and we will file a written brief of 10 or 12 pages. That's all. But I don't want to be impeded. My request also, which is on record, my application, which you will find the prayer at page 141, is only to make legal submissions. Intervention, not impediment, and only page 141.
To be very frank, normally it's a list between the parties. So it can be having a minor repercussions.
But this time,
there's a principle of there's a principle of pursuing supply there.
Sorry,
That's a principle of pursuing supply there after tribunal. That's the principle of
yes, of course it applies because what will happen? Okay, so that's what we have projected in our application. What will happen is that if this CRC norm comes to be accepted in terms of manner of computation of the annuity, then and upheld by appel, then all the other electricity regulatory commissions in a similar situation will apply. So it has a sectoral impact across the board.
Right.
Of the individual.
Yes.
Yes, certainly.
Where the CERC's order is referred to.
Yes, yes.
And the appels.
Where we have changed the law.
Individual order. It is not a common order.
No, so let's be very clear. Let's be very clear. What your Lordship says is absolutely correct. This is an individual determination of tariff in the case of respondent number 1 company before your Lordship, which is ACME Acme Bhiwadi Solar Power Private Limited. But what CRC has done by determining them, they have formed a principle. So the question of law, which is going to arise, there may be several other questions, but the one I am interested in is just this, which is the appropriate annuity rate, because it will apply to all solar manufacturers. Sorry. May I just answer your question? Just go to page 23, please. I'm only answering the question. The question is this not individual specific case of one person? Now, 23 has a full tabulated statement of 9 orders which have now followed the CERC order.
issue notice return to package is not to audited without audited
16th January. Oh, sorry, this September. 25th September.
was passed in a similar matter. That's the ratio. The issue of office returned in the week of message. That is the appeal district.
Because may I take Gusty here, basically. 28th of February. I'll take Gusty for this.
The week of message. 17th of February 2025. Votes will be served by all votes including Gusty. We will be given a short date as it is stated that the appeal is listed for hearing before the appellate tribunal on which date?
Days before the appeal.
The next date before the appeal, I'm told, is 28th February.
On 28th February 2025.
Your Lordship's returnable date is
17th, we commence 17th of February.
Could it be 21st? But 21st, yes, sir.
Commencing that, then be a very short order, it's not very complicated issue.
No, it's not. No, it's just around the 17th of February if it's I'm not present. That's all.
No, it will come up in the recommence.
Over and very good. Okay.
Or you want 21st, I give it on 21st, but if suppose it is.
No, that's not good. Yeah, you are not.
The recommence in 21st, I make it.
No, 21st is I think a Friday. It's a Friday.
No, I'll have to make it on recommence in 24th, sir.
Alright, 24. 24.
Commence in 24th.
But this is the matter I mentioned in the morning.
We are not talking about
Yes, Lord. Lord, this is by the wife. What has happened is, Lord, my client, Lord, he is a businessman.
Yes.
In December of 2023, he went to Dubai for work. He's taken a permit of work.
What is the case against him here?
Now, what has happened is, Lord,
What is the case against him here?
that's what I'm coming to, Lord. There were 3 complaints made by 3 individuals saying their PAN cards, etc., have been misused for registration of 3 fake firms, which have then undertaken business, and they have, there is a fraud alleged of GST evasion of false claims. Now, Lord, how this is proceeded is, I got in the original complaint.
Says, what is the date of the FIRs?
Lord, this is June. They are all June 2023.
So, since 2023, you have absconded.
No, I can't abscond. Because I went with a valid document. I went in December 23. I've been doing business over there. I'm an Indian. I'm holding a passport. I have not heard from them. Not a single notice. My Indian numbers are working, Lord. I have not received any message from them. Then what happens, Lord? For business, I travel from Dubai to Malaysia and from Malaysia to Indonesia.
When did you leave India?
In December 23. 6 months after that.
Since then, you are not back in India.
I've taken a work permit over there. I'm working.
You come to India, we'll see.
I want to. That's my petition. Just allow me to complete what is happening.
India, we'll see.
No, that's exactly what I'm saying. I'm not asking for anything more. What is that? Just allow me to tell your lordship the facts. What
Notice a blue corner notice, not a red corner.
No, it's not red corner. Lord. This is probably because what is just allow me because your lordship has not read the file. So I went to Malaysia for work. From Malaysia, I went to Indonesia. When I landed in Indonesia for the first time, I am told there is a blue corner notice because of some proceedings against me in India. And they send me back to Malaysia. From Malaysia, when I want to go back to Dubai, they say, no, we will not permit you. Today, I am stranded in Malaysia. I am a diabetic. I want to come to India. They have in the meantime revoked my passport. With the result, I am stateless. Where do I go? All that I am saying is,
come back to India.
That's exactly what I am wanting. Lord, I am not saying anything more, just kindly help me. Yes, that's all I want. I want to come and join the proceedings. I am willing to surrender before the court. No difficulty at all, Lord.
You cancel your passport, you aggressively give you a temporary permit to come back to.
That's all that I want to know. Your Lordship may say, I will come and surrender. This is my undertaking to the court. Let them.
You please come back to they do that themselves. They have detained you now in Malaysia because you are person operator because your passport has been.
So, Lord, your Lordship may only issue a direction.
Now what they do is they give you a temporary permit to travel.
That's the only direction. Only for that limited purpose, your Lordship may call upon the union.
What is the prayer in the petition?
Lord, prayers may be broader, but your Lordship may restrict it to that. I have said that this blue corner notice be set aside.
What is the difference between a blue and a red? What is the difference between a blue and a red?
That will not be
reported back. In blue, you have to be there at that port. You cannot go outside the port, and you have to go back to the country.
So they want it to take you here. They want to come back. They want you to come back.
I'm saying I'm wanting to come back.
So then what's wrong with blue corner notice?
No, I'm not. Very well, your Lordship may ignore that. Your Lordship knows that.
We accept your prayer in prayer. We accept your prayer.
That's what I'm saying. Let them issue the appointment and let me be brought or let me come back whichever way. I want to come back and join the proceedings. I'm not running away.
Meaning of this blue corner notice is that you will stay put wherever you want.
At the airport itself, and you have to come back. So red corner probably cannot be deported. Are you allowed to deport? Red corner will be deported. No. Deported? No.
No, this is what
red corner, according to Lord, I have not quite frankly examined.
Red corner notice, you are deported. Yes. So blue corner notice, I have not.
Yes.
But so then the passport has been revoked.
And my Lord, I moved the trial court for cancellation of NBW because they have obtained an NBW against me.
Right.
The trial court says
they submitted on behalf of the petitioner that the petitioner should be deported to India and has no objection in this regard. To stop. The statement I made, in view of the statement, we relist in the week of relist on Monday, or make it to the Tuesday. Relist also, so notice will be issued to the central agency to nominate council who will obtain instruction. To stop. Copy of this order will be also can be also used as an task for the petitioner for making a prayer to the authorities in relation that he may be deported to India.
You are incarcerated now.
I'm held, not incarcerated, but by the Malaysian authorities, I'm not allowed to enter Malaysia. And I'm just being held there at the
end. There may be 2-3 more violations. Because your passport has been cancelled. There may be violation of the Malaysian law.
Lord,
I don't know. There may be violation of Malaysian law. Because you entered into that, came into that report after a cancellation of passport.
No, that I learned of it. I went to Malaysia validly. I went to Indonesia. At Indonesia, I am told there is a blue corner notice. We will send you back.
Correct. I don't know.
Back to Malaysia.
You be sent back to Malaysia.
Yes.
So I don't know whether you may have violated the Malaysian law. They insist that till the punishment of the Malaysian law is first met by you, we will not deport you. That's the problem.
Lord, he is a diabetic. He is being treated by the Malaysian authority.
Not issue directions to the Malaysian authority.
No, we are not even wanting that. All that, my Lord, what happened? I moved the trial court for cancellation of NBW.
He does not press for other release. He does not press for other release.
No, my Lord, my grievance is also when I moved the trial court for cancellation of NBW. We not there, therefore application.
Correct, right? You have been absconding.
Not absconding, my Lord. I'm saying I made a statement.
Could I come to India instead of going to Indonesia? What prevented you from going to Indonesia? Coming to India rather than going to? Could I come to India? But come next week on 20th of April.
Prediction.
Yeah, prediction.
আমি বলতে চাই নো পলিটিক্স। আজকের আমরা যে বিষয়ে আলোচনা করব এবং কিছু গুরুত্বপূর্ণ কথা তোমাদেরকে বলবো এবং তোমাদের কাছে কিছু প্রশ্ন থাকবে যার উত্তর একমাত্র তোমরা দিতে পারো। তো প্রথমে বলে নিচ্ছি, আমরা এই চ্যানেলে কোনো রাজনৈতিক আলোচনা করতে বা চাই না, কিন্তু আজকের আলোচনাটা না করলেই নয়। আজকের আলোচনাটা না করলেই নয়। তো আমরা আলোচনা প্রথমে বলছি, কেউ পলিটিক্যাল ভাবে জিনিসটা নেবে না, পলিটিক্যাল ভাবে জিনিসটা নেবে না, এটুকু শুধু তোমাদের কাছে অনুরোধ থাকবে, পলিটিক্যাল ভাবে না নেওয়াই বেস্ট। তো আমাদের দেখো, আলোচনার মেন বিষয় ছিল আজকের আমরা যে বিষয়ে আলোচনা করব, আমার থেকে ভালো তোমরা উত্তর দিতে পারবে। আজকে যে আলোচনার মূল বিষয়বস্তু, আমার থেকে ভালো তোমরা ভালো উত্তর দিতে পারবে।
ऐसा बेहतर खाना पीना और रहना कहीं नहीं देखा।
भोजन बहुत ही स्वादिष्ट था और ये प्रबंध बहुत
আবার বলছি শুরু করার আগে যে তোমরা কেউই বিষয়টাকে রাজনৈতিক ভাবে নিও না। যদি দিদি মানে আমাদের মমতা দিদি, আমাদের মাননীয় মুখ্যমন্ত্রী যদি নিয়োগ না করে, তাহলে কি 2026-এর বিধানসভা নির্বাচনে ক্ষমতায় আসবে? কোটি টাকার প্রশ্ন। সমস্ত হবু শিক্ষক, হবু পিএসসি অ্যাসপিরিয়েন্ট, পুলিশ অ্যাসপিরিয়েন্ট, হবু অন্যান্য যত পশ্চিমবঙ্গে যত চাকরি প্রার্থী, বেকার শিক্ষার্থীরা আছে এবং বঞ্চিত প্রার্থী যারা আছে, তাদের কাছে একটাই প্রশ্ন যে যদি আমাদের মমতা দিদি, আমাদের বর্তমান মুখ্যমন্ত্রী, তিনি যদি নিয়োগ না করেন, রিক্রুটমেন্ট না করেন, সেটা পুলিশ রিক্রুটমেন্ট হতে পারে, সেটা ডাব্লিউপি রিক্রুটমেন্ট হতে পারে, বা তোমাদের পিএসসি রিক্রুটমেন্ট হতে পারে, এই রিক্রুটমেন্ট গুলো যদি না করিয়ে যদি নির্বাচন শুরু করে দেয়, অর্থাৎ 26-এর বিধানসভা নির্বাচন চলে আসে, তার মধ্যে যদি রিক্রুটমেন্ট না করে, তাহলে কি আমাদের দিদি ক্ষমতায় আসতে পারবে? তোমাদের মতামত কি বলছে? দেখো, আমি কিছু কথা বলার আগে বলে নিচ্ছি, আমি সমস্ত ধর্মকে, প্রত্যেকটি ধর্ম, সেটা হিন্দু ধর্ম হোক, খ্রিস্টান ধর্ম হোক, বৌদ্ধ ধর্ম হোক, জৈন ধর্ম হোক, মুসলিম ধর্ম হোক, প্রত্যেকটা ধর্মের মানুষকে আমি সমানভাবে রেসপেক্ট করি, সম্মান করি। আমার সমস্ত ধর্মের মানুষের কিন্তু বসা আছে, আমি সমস্ত ধর্মের মানুষকে সমানভাবে মানুষের চোখে দেখি। আমার কাছে একটাই পরিচয়, সে সবার আগে মানুষ, রক্ত মাংসে গোড়া মানুষ, আর সবাইকে আমি সমানভাবে ভালোবাসি। আমার কাছে যে কোনো ধর্ম ছোট, কোনো ধর্ম বড়, এই নিয়ে কিন্তু কোনো ভেদাভেদ আমার মধ্যে অন্তত নেই। তো আমার প্রশ্ন হচ্ছে, আমি কোনো ধর্মকে ছোট করতে চাই না বা ছোট করবো না আমার কথার মধ্যে। যদি কোনো কিছু ভুল ভ্রান্তি হয়ে যায় অবশ্যই ক্ষমা করে দেবে। আমি এটুকু বলতে চাই যে কোন সমীকরণ নিয়ে আমাদের দিদি ক্ষমতায় আসবে। আচ্ছা, কি বলছো একজন কমেন্টটি করেছো, দাদা নিয়োগ করুক না করুক টিএমসি আসবে দাদা, 30% মুসলিম ভোট, 14% হিন্দু ভোট। দাদা মুসলিম ভাইরা কিন্তু মুসলিম ভাইরা কি বলছো, বিএড করে কিন্তু জব পাক না পাক টিএমসি কে ভোট দেবে। আচ্ছা আচ্ছা, বলছে মুসলিম ভাইরা বিএড করে জব পাক না পাক টিএমসি কে ভোট দেবে। দেখো, একটা প্রশ্ন, সবচেয়ে বড় প্রশ্ন যেটা 2026-এর যে বিধানসভা নির্বাচন, সেখানে আমাদের দিদি ক্ষমতা আসতে পারবে কিনা। আমরা দেখলাম বিভিন্ন অলরেডি বিভিন্ন যে সকল ফ্যান পেজ আছে, সেটা ফেসবুক পেজ হতে পারে, ইউটিউবে বিভিন্ন জায়গায় আমরা দেখলাম কিন্তু অলরেডি তোমাদের বিভিন্ন আন্দোলন বলতে পারো, বিভিন্ন সভা কিন্তু শুরু হয়ে গেছে। দলীয় নেতা নেত্রীরা কিন্তু অলরেডি সংগ্রাম শুরু করে দিয়েছে, ঠিক আছে, তারা তাদের কিন্তু মানে প্রস্তুতি শুরু করে দিয়েছে। এবার প্রশ্ন হচ্ছে কিভাবে দিদি ক্ষমতায় আসবেন এই সামনের 26 বিধানসভা নির্বাচনে, কিভাবে ক্ষমতায় আসবেন? আমরা যদি দেখি একাধারে পশ্চিমবঙ্গে এই যাবৎকালের মানে পশ্চিমবঙ্গের বুকে এই যাবৎকালের সবচেয়ে বড় দুর্নীতি যদি হয়ে থাকে আমাদের এই সরকারের শাসন আমলে হয়েছে। তারপরেও যত ভোট হয়েছে তত ভোট কিন্তু বেড়েছে। আমাদের তৃণমূলের একজন নেতাই বলবো, অন্য কিছু বলবো না, নেতাই বলবো, দেবাংশু নাম করে, দেবাংশু ভাবে নাম করে, তিনি বলছিল যে আফটার নারদা 22 নারদার পরে মানে সিট সংখ্যা বেড়েছে, সারদা কাণ্ড কম ছিল, সারদা কাণ্ডের পরে সিট সংখ্যাও বেড়েছে। তার মানে আমাদের ওই নেতা বোঝাতে চেয়েছেন এটাই যে আমরা যত দুর্নীতি করব তত আমাদের ভোট বাড়বে। আবার আমরা দেখেছি যে শিক্ষক রিক্রুটমেন্ট হোক, আজ আমরা দেখেছি যে 10 বছর, আচ্ছা এখানে যদি আমি বারবার বলে দিচ্ছি, এখানে যদি কোনো যে ধর্মেরই হোক বা যে পার্টিরই হোক, আমি সবাইকে অনুরোধ করবো এটা পলিটিক্স হিসেবে নিও না, আমি তোমাদের সাথে কথাগুলো বলছি। দেখো আজ আমরা দেখছি যে 10 বছর SLST রিক্রুটমেন্ট হয় না, 10 বছর আপার প্রাইমারি রিক্রুটমেন্ট হয় না, 10 বছর SLST রিক্রুটমেন্ট হয় না, 10 বছর আপার প্রাইমারি রিক্রুটমেন্ট হয় না। PSC রিক্রুটমেন্ট WBCS এর একটা রিক্রুটমেন্ট করতে 57 বছর লাগিয়ে দেয়। ফুড এসআই এর পরীক্ষা যদিও হয়, তার প্রশ্ন আউট হয়ে দুর্নীতি করে সেটা বছরের পর বছর কেস হয়ে ঝুলে আছে গেল। তারপর আমরা যদি চলে আসি যে প্রাইমারি শিক্ষকের কথা বলি, প্রাইমারিতে 17 সালে শেষ রিক্রুটমেন্ট হয়েছে, 17 সালের যে টেট, সেই টেটের রিক্রুটমেন্ট এখনো পর্যন্ত চলছে। এবং আমরা অন্যান্য যত রিক্রুটমেন্ট আছে সমস্ত রিক্রুটমেন্ট কিন্তু বন্ধ করে রেখে দিয়েছে ওবিসি কেসের বাহানা দিয়ে। অথচ কিন্তু সুপ্রিম কোর্ট থেকে বলেছে যে আমাদের ওবিসি কেসটা কোনো মানে ওবিসি কেসের জন্য কোনো রিক্রুটমেন্ট বন্ধ করে রাখার প্রয়োজন নেই। তো এছাড়াও সারদা নারদা বিভিন্ন রকম যে দুর্নীতি, কর্মসংস্থান নেই, তারপরেও কিন্তু আমাদের পশ্চিমবঙ্গ ভারতের মধ্যে সবচেয়ে প্রথম স্থান অধিকার করেছে, সেটা কর্মসংস্থানের দিক থেকেই হোক বা স্বাস্থ্যের দিক থেকেই হোক, এটা আমাদের দিদি বলেন। তাহলে এত সুন্দর সমীকরণের পর যদি শিক্ষক রিক্রুটমেন্ট না করে বা যদি পুলিশ রিক্রুটমেন্ট না করে বা যদি PSC রিক্রুটমেন্ট না করে, তাহলে কি দিদি আমাদের ক্ষমতায় আসবে? হ্যাঁ, ক্ষমতায় আসবে। কোন সমীকরণে ক্ষমতায় আসবে? সমীকরণ হচ্ছে এটাই, দেখো। আচ্ছা কি বলছো সমীকরণ? বলছো দাদা আমাদের ইন্টারভিউ নিয়োগ নিয়ে কিছু আপডেট থাকলে দিন। আচ্ছা কি বলছো ঘোষ? বলছো বিজেপি 40%, TMC 44%, মুসলিম ভোট 30/30, তাই মুসলিম ভোট। আচ্ছা আকাশ বলছো লক্ষ্মীর ভান্ডার 2000 করে দিলে দাদা সবাই খুশি, চাকরি প্রার্থীদের কষ্ট শুধুমাত্র চাকরি প্রার্থীরাই এবং তাদের ফ্যামিলিরাই বোঝে। একদম তোমার কথার সঙ্গে 100% একমত। আচ্ছা তোমাদের সঙ্গে সম্পূর্ণ একমত। অ্যাকচুয়ালি একজন বেকার সে বোঝে আর তার পরিবারের মানুষজন বোঝে। তবে আমি এটুকু তোমাদের বলি যে কোন সমীকরণের ক্ষমতায় আসে আমাদের দিদি, দেখো হ্যাঁ এটা বাস্তব কথাই। আমাদের রাজ্যে 70%, 60 থেকে 65% হয়তো তোমার হিন্দু সম্প্রদায় আছে, আর 30% প্লাস আছে মুসলিম সম্প্রদায়, এছাড়া অন্যান্য সম্প্রদায় মিলিয়ে টোটালে 100% যে ভোট। তার মধ্যে মুসলিম সম্প্রদায় ভাই বোনেদের যে ভোট, সেখানে শিক্ষিত যে সকল মুসলিম সম্প্রদায়ের ভাই বন্ধুরা আছে, যারা সচেতন, যারা বেকারত্ব যারা বোঝে, যারা শিক্ষিত মুসলিম, যারা জ্ঞানী, যারা পড়াশোনার মধ্যে আছে, তারা হয়তো কিছুটা হলেও হয়তো বিবেচনা করে। আমি বলছি না যে তুমি TMC কে ভোট দাও না, বা আমি কখনো বলবো না যে তুমি ওই দলকে ভোট দাও, ওই দলকে, তোমার ইচ্ছা, তোমার ব্যক্তিগত ব্যাপার, তুমি যাকে খুশি তাকে দাও। কিভাবে TMC ক্ষমতায় আসে সেটা একটু তোমাদের এক্সপ্লেনেশন করতে চাই। তো আমাদের এই মুসলিম সম্প্রদায়ের যে ভাই বোনেরা আছে, তাদের মধ্যে একটা ভয় এমন ভাবে ঢুকে দেওয়া হয়েছে যে যদি টিএমসি বাদে অন্য কোনো দল ক্ষমতায় আসে, টিএমসি বাদে যদি অন্য কোনো দল ক্ষমতায় আসে, তাহলে তোমাদের এই দেশ ছেড়ে চলে যেতে হবে, রাজ্য ছেড়ে চলে যেতে হবে, বা তোমাদের এক পেশে করে রাখবে, বা তোমাদের কথা বলতে দেওয়া হবে না, তোমাদের বাক স্বাধীনতা কেড়ে নেওয়া হবে, এরকম একটা ভয়ভীতির মধ্যে রাখা হয়। তার জন্য কিন্তু মুসলিম ভাই বোনেরা বা যে সকল যারা আছে তারা কিন্তু একটা ভয়ের মধ্যে থাকে যে আমাদের এই যে দল ক্ষমতায় আছে এরা আছে বলে আমরা তো কথা বলতে পারছি, অন্য কোনো দল আসলে হয়তো আমরা কথা বলতে পারবো না, চলাফেরা করতে পারবো না, সেই একটা কিন্তু আতঙ্ক মুসলিম ভাই বোনদের মধ্যে কাজ করে। এবং সেই স্বার্থ থেকে সেখান থেকে বেশিরভাগ আমরা বলছি শিক্ষিত যারা প্রকৃত শিক্ষায় শিক্ষিত মুসলিম সম্প্রদায়ের ভাই বোনেরা, অনেক শিক্ষিত বোনদের সঙ্গে আমাদের কথা হয়, মুসলিম শিক্ষিত ভাই বোনদের সঙ্গে কথা হয়, তারা কিন্তু দুঃখ প্রকাশ করে, তাদের কথা শুনি, তাদের কথা শুনলেও খারাপ লাগে, কষ্ট হয় যে তারা কিন্তু বেকার। এমন তো না যে তাদের জন্য আলাদা কোনো ফ্যাসিলিটি ব্যবস্থা করা হয়েছে, তাদের সেই সম্প্রদায়ের মানুষদের জন্য চাকরির ব্যবস্থা করা হয়েছে, এমন তো কিন্তু কিছু না, তো সবাই বঞ্চিত। তো এই যে মুসলিম সম্প্রদায়ের মানুষগুলো এরা কিন্তু বুঝেও আবার অবুঝ হয়ে যায়। কেন? কারণ তারা তখন পিছনের কথা ভাবে যে আমাদের হয়তো দেশ থেকে তাড়িয়ে দেবে, আমাদের হয়তো এই রাজ্য থেকে তাড়িয়ে দেবে অন্য যে কোনো দল, সেটা তোমাদের কংগ্রেস আসুক, সেটা তোমাদের সিপিএম আসুক বা বিজেপি আসুক, যে দলে আসুক না, এই ভয়টা কাজ করে। এই ভয়ের জন্যই কিন্তু আমাদের রাজ্যে ভোট কিভাবে দেখো, তবে এটা সাধুবাদ জানাতে হয় যে মুসলিম সম্প্রদায়ের ভাই বোনদের মধ্যে একটা একতা আছে, মুসলিম ভাই বোনদের মধ্যে একটা একতা আছে, একটা ঐক্যবদ্ধ আছে, ওরা কিন্তু যা করে সবাই একতা হয়ে করে। কিন্তু আমাদের হিন্দু সম্প্রদায়ের মধ্যে সেই একতাটা নেই। মানে কেমন, তোমাদের একটা সিম্পল উদাহরণ, বাস্তব উদাহরণ বলছি। মনে করো রাস্তায় কোনো এক হিন্দু বিপদে পড়েছে বা কারোর সঙ্গে কোনো ঝামেলা লেগেছে, তো তার পাশের বাড়ি যদি কোনো হিন্দু সেখানে দেখেও যে সে মার খাচ্ছে বা ঝামেলা লেগেছে, সে কিন্তু পাশ কেটে বেরিয়ে আসবে, বা যদি মারামারি লেগে যায় সে পাশ কেটে বেরিয়ে আসবে, সরে আসবে ওখান থেকে, ওর ঝামেলা আমি কেন জড়াতে যাবো, আমি জড়াবো না, আমি চলে যাই। বেশিরভাগ 100% এটা হয়তো লাগতে পারে, 100% এর মধ্যে 90% হিন্দুরাই কিন্তু নিজেকে সবসময় সেপারেট রাখে, আমি ওর সময় ঝামেলা জড়াবো না। কিন্তু একটা মুসলিম সম্প্রদায়ের ভাই বোনদের মধ্যে যদি শুধু জানতে পারে সেই মুসলিম ভাইটা যে এই আমার সম্প্রদায় বা আমার জাতের ছেলে বা মুসলিম সম্প্রদায়ের বা একই জাতের, তখন কিন্তু না দেখবে না আমার ভাই, না আমার বোন, না আমার কি পরিচিত, তখন দেখবে না, তখন দেখবে ও আমার সজাগ বা আমার ধর্মের মানুষ, ও বিপদে পড়েছে, পাশে দাঁড়াতে হবে। এই একতাটা কিন্তু মুসলিম সম্প্রদায়ের মানুষের মধ্যে হিন্দুদের থেকে বেশি। যে হিন্দুদের মধ্যে নেই তা না, হিন্দুদের মধ্যে অবশ্যই আছে, কিন্তু মুসলিমদের মধ্যে এটা কিন্তু একটু বেশি। আমরা দেখেছি, আমাদের বাস্তবতা রাস্তাঘাটে দেখেছি, এবং এই জন্যই বলি মুসলিমদের মধ্যে কিন্তু একতা আছে। আর যদি, কেন বলছি, যদি হিন্দুদের মধ্যে একতাটা থাকতো তাহলে কিন্তু আমরা দেখেছি যে মুসলিম ভোট কি হয়, মুসলিম ভোটগুলো ভাগাভাগি হয় না, 100% ভোট কিন্তু 100% ভোট কে পায়, আমাদের শাসক দল পেয়ে যায়। ওই আমি তোমাকে বলি, একটা এলাকায় যদি 1000 ভোট থাকে মুসলিম ভোট, তার মধ্যে হয়তো ওই 10টা বা 100টা ভোট হয়তো অন্য দল পায়, সিপিএম দিয়ে, কংগ্রেস দিয়ে, বিজেপি দিয়ে এরা পায়। আর বাকি যে 900 ভোট, সেই 900 ভোটে কিন্তু মুসলিম পায়, টিএমসি পায়। আর যে হিন্দু ভোট, যে হিন্দুদের মধ্যে একতা নাই দেখো, আর যে হিন্দু ভোট গুলো, সেই হিন্দু ভোট গুলো কি হয়, সেই হিন্দু ভোট গুলো ভাগাভাগি হয়। কারণ হিন্দুরা তো নিজের পায়ে নিজেরাই খবর মারে। তো কি বললে, সমবংশ বাঙালি হলো কাকড়ার জাত, হ্যাঁ ঠিক বলেছো। আর হিন্দু ভোট গুলো কি হয়, হিন্দু ভোট গুলো ভাগাভাগি হয়। হিন্দু ভোট গুলো মনে করো তোমাদের 100% ভোট ওই কোথাও 60% শাসক দল পাচ্ছে, বা 40% অন্য দল পাচ্ছে, বা কোথাও ওই 45, কোথাও 55, এরকম। এই যে 40-50 কিন্তু ভাগাভাগি হয়ে যায়। এই ভাগাভাগি হওয়ার জন্যই কিন্তু এখানে কিন্তু ফায়দা হচ্ছে শাসক দলের, মানে বর্তমান যে শাসক দল ক্ষমতায় আছে, এভাবেই কিন্তু আমাদের শাসক দল ক্ষমতায় আসে। তাছাড়া যদি আমাদের হিন্দুদের মধ্যে একতা থাকতো, যদি হিন্দুরা যদি একত্রিত হতো, তাহলে আমাদের শাসক দল বর্তমান যেভাবে বলবো কর্মসংস্থান বন্ধ করে রেখেছে, যেভাবে আমাদের বেকারদের যে যন্ত্রণা, কিছুদিন আগে দেখলাম একজন SLST শিক্ষক মারা গেল, একজন হবু শিক্ষক মারা গেল, একজন প্রাইমারি শিক্ষক মারা যাচ্ছে, এরকম অনেক পুলিশ মারা গেছে, হবু পুলিশ যারা পুলিশের স্বপ্ন নিয়েছিল বিভিন্ন কিছু কারণে। বিভিন্ন পত্রপত্রিকায় রেগুলারলি দেখছি যে বেকারত্বের জ্বালা থেকে মুক্তি পেতে বা যন্ত্রণা সহ্য করতে না পেরে আমরা কিছুদিন আগে দেখলাম যে 26,000 চাকরি বাতিল মামলার জন্য কিছু একজন যোগ্য শিক্ষক মারা গেল। তো আর তার চেয়েও বড় কথা দেখো, আমি আবারও বলছি, আমি কোনো ধর্মকেই অসম্মান করছি না, কারণ সব ধর্মের মধ্যে ভালো মন্দ আছে। দেখো একটা জিনিস, আমরা এই কিছু আজকে দেখলাম, আমি আমার ফেসবুক পেজে থেকে পোস্ট করেছি যে সেখানে সরস্বতী পূজা হয়েছে। তো সেখানে সরস্বতী পূজা দেখলাম যে ছেলেটা বলছে যে আমাদের এখানে কোনো মানে সুযোগে কোনো এক সময় রাতের অন্ধকারে এসে সেই সরস্বতী প্রতিমার গায়ের থেকে সমস্ত বস্ত্র খুলে নিয়ে তার সর্বশরীরে শুধু কামড়ের দাগ, সরস্বতী প্রতিমার কামড়ের দাগ। তো এইগুলো কোন ধরনের মেন্টালিটি মানুষ? দেখো আমি বলছি যে এগুলো যারা করেছে তারা কিন্তু সে যে ধর্মেরই হোক, সে যে ধর্মের মানুষই হোক, সে একজন বিকৃত মনের মানুষ ছাড়া, বিকৃত মানসিকতার মানুষ ছাড়া এরকম কাজ কিন্তু করতে পারে না। কোনো ভালো মুসলিম ধর্মের মানুষই হোক, ভালো খ্রিস্টান ধর্মের মানুষই হোক, কখনো এই কাজ সজ্ঞানে কেউ করতে পারে না। এগুলো কারা করে? এই বিকৃত কিছু মানুষের জন্য। আর এই বিকৃত কিছু মানুষের জন্য কিন্তু কিছু কিছু মানে কিছু দু একজন বিকৃত মানুষের জন্য কিন্তু বদনাম হয় পুরো যাত্রার, পুরো সম্প্রদায়টার। যে সম্প্রদায়ের মানুষই করুক না কেন, এই দুই একজনের খারাপ কর্মের জন্য সবার কিন্তু বদনাম হয়। তো আমি এটুকুই তোমাদের কাছে প্রশ্ন থাকবে, যে প্রশ্নটা হচ্ছে যে যদি আমাদের দিদি 26-এর বিধানসভা নির্বাচনের আগে যদি আমাদের রিক্রুটমেন্ট না করে, আমি বলছি যদি 26-এর বিধানসভা নির্বাচনের আগে যদি তোমাদের রিক্রুটমেন্ট না করে, সেটা তোমাদের পুলিশ রিক্রুটমেন্ট হোক, সেটা তোমাদের পিএসসি রিক্রুটমেন্ট হোক, ডাব্লিউবিসিএস হোক, মিসলেনিয়াস হোক, ক্লার্কশিপ হোক, ফুড এসআই হোক, বা তোমাদের টিচার রিক্রুটমেন্ট হোক, প্রাইমারি টিচার, SLST, হ্যাঁ, তোমাদের আপার প্রাইমারি যদি রিক্রুটমেন্ট না করে, আমি তোমাদের অনুরোধ করবো, দেখো আমি কিন্তু কোনো দলের সাপোর্টার না, রিয়েলি বলছি, বিশ্বাস করো, আমি কোনো দলেরই সাপোর্টার না। এখন বর্তমান শাসক দল বেকারদের জীবন নিয়ে যেভাবে ছিনিমিনি খেলছে, এই জন্য বলতে বাধ্য হচ্ছি যে আমি কিন্তু ভেবো না যে আমি এরকম বলছি বলে আমি কোনো দলকে সাপোর্ট করি, আমি মোটেই কোনো দলকে সাপোর্ট করি না। আমার কথা যদি কেউ শুনে থাকো তাহলে পূর্ব থেকে রেখে আসো, বুঝতে পারবে। আমি আজকে একটা দেখো আমার ফেসবুক পেজে একটা আপলোড করেছি রিপোর্ট, যেখানে আমাদের ভারতবর্ষ মানে উন্নয়নের দিক থেকে, প্রভাবশালীর দিক থেকে কতটা পিছিয়ে পড়েছে। তো সেখানে আমাদের কেন্দ্র সরকারও কোনো উন্নয়ন করছে না, আমাদের কোনো কিন্তু ডেভেলপমেন্ট নেই। সে যাই হোক, আমি সেসব বিষয়ে আসছি না, যে বিষয়ে বলছি। তো আমি এটুকুই বলছি, শুধু এটুকু তোমাদের বলতে চাইছি, আমি কোনো দলের সাপোর্টার না। তবে আমরা যদি এই রাজ্যে বাস করি, আমরা যে রাজ্যে বাস করি, যে রাজ্যে আমাদের পেট চলবে, সেই রাজ্যটাকে আমাদের উন্নয়নের দিশায় নিয়ে যেতে হবে। তো আমি এখান থেকে বলছি না যে তোমরা অমুক দলকে ভোট দাও, তোমাদের যাকে ইচ্ছা ভোট দাও, তোমাদের যাকে মন চায় তাকে ভোট দাও। শুধু এটুকুই বলবো, যদি আমাদের 26-এর নির্বাচনের আগে, আমি বলছি 26-এর নির্বাচনের আগে যদি আমাদের পুলিশ রিক্রুটমেন্ট কমপ্লিট না করা হয়, জয়েন পর্যন্ত, শুধুমাত্র পরীক্ষা নিয়ে মঞ্চে উঠে ডায়লগ দিয়ে বেড়াবো যে আমরা এত হাজার পরীক্ষা নিয়েছি, এই রিক্রুটমেন্ট হবে, ওবিসি কেসের জন্য আটকে ছিল, এর জন্য এটা করতে পারেনি, ওটা করতে পারেনি, যদি এরকম অজুহাত দেওয়া হয়, একটা দুটো পরীক্ষা নিয়ে সামনে ভোটের আগে পরীক্ষা নিয়ে সব মঞ্চে এত লক্ষ লোক নিয়েছি, আমি তোমাদের বলবো, যদি 26-এর বিধানসভা নির্বাচনের আগে, আমি বলছি আমার ভিডিওটাকে শেয়ার করো পারলে পরে, 26-এর বিধানসভা নির্বাচনের আগে যদি পুলিশ রিক্রুটমেন্ট, যদি তোমাদের পিএসসি রিক্রুটমেন্ট, সেটা ফুড এসআই হোক, পিএসসি মিসলেনিয়াস হোক, ডাব্লিউবিসিএস হোক, ক্লার্কশিপ হোক, যত পরীক্ষা আছে, যত পরীক্ষা এখনো পর্যন্ত হয়ে গেছে বা তোমাদের নোটিফিকেশন দেওয়া রয়েছে, ফর্ম ফিল আপ করা আছে, তোমাদের টিচার রিক্রুটমেন্ট হোক, প্রাইমারি টিচার, SLST 10 বছর হয় না, আপার প্রাইমারি রিক্রুটমেন্ট, এই রিক্রুটমেন্ট যদি কমপ্লিট না হয়, যদি কমপ্লিট এই সরকার না করতে পারে, সরকারকে বহুত সুযোগ দেওয়া হয়েছে, আজ 15 বছর ধরে সরকার ক্ষমতায় রয়েছে, এই 26-এর নির্বাচনের আগে, আবারও বলছি, যে আগে যদি রিক্রুটমেন্ট সম্পূর্ণ না করে, তাহলে তোমরা অন্য দলকে বেছে নাও, অন্য যে কোনো দলকে বেছে নাও, এটা আমার মন্তব্য, আমার একান্ত ব্যক্তিগত মন্তব্য। যদি নিয়োগ না করে, যদি রিক্রুটমেন্ট কমপ্লিট না করে, তাহলে তোমরা অন্য দলকে বেছে নাও। তবে একটা বিষয় পরিষ্কার, যে সরকারের বেকারদের ভোটের কোনো প্রয়োজন নেই, সেটা কিন্তু সরকার দেখিয়ে দিয়েছে, কিন্তু তোমরা সেটা দেখাতে পারো নি। তোমরা সেটা দেখিয়ে দাও, তোমাদের ভোটের কত বেকারদের ভোট, আমাদের বেকার বলতে যুবক, বেকার যুবক, আর আমাদের পশ্চিমবঙ্গে বেকার যুবক কিন্তু বেশি, আমাদের পশ্চিমবঙ্গে বেকার যুবক বেশি। তো পশ্চিমবঙ্গে বেকার যুবকদের কোনো প্রয়োজন নেই, তাদের রিক্রুটমেন্ট করানোর কোনো প্রয়োজন নেই, সেটা কিন্তু আমাদের এই সরকার সেটা প্রমাণ করে দিয়েছে বিগত কয়েকটা ভোটে, যে শিক্ষক রিক্রুটমেন্ট না করেও তো আমরা ক্ষমতা এসেছি, পিএসসি রিক্রুটমেন্ট না করেও তোমরা ক্ষমতা এসেছি, বেকারদের চাকরি না দিয়েও তোমরা ক্ষমতা এসেছি। 10 লক্ষ 15 লক্ষ বিএড ক্যান্ডিডেট আছে, 5 লক্ষ 7 লক্ষ ডিএড ক্যান্ডিডেট আছে, পাস করে আছে 12 করছে লক্ষ লক্ষ ক্যান্ডিডেট, তাহলে এরা তো নিশ্চয়ই বেকার, যারা করছে চাকরির জন্য প্রস্তুতি নিচ্ছে। এই যে লক্ষ লক্ষ ছেলে মেয়ে, তাদের তো নিশ্চয়ই পরিবার আছে। তুমি একজন বেকার, তোমার বাড়িতে তো পরিবার আছে, পরিবার একজনের পরিবারে 10 জন 12 জন করে ছেলে মেয়ে আছে, বা 4 জন 5 জন করে ছেলে, মানে 4-5 জন করে পরিবারের সদস্য আছে। তো এবার বেকারদের শক্তিটা দেখিয়ে দাও। যদি আমাদের বিধানসভা নির্বাচনের আগে রিক্রুটমেন্ট প্রসেসিং কমপ্লিট না করে, আবারও বলছি এটাকে প্রয়োজনে পারলে করে শেয়ার করো, যদি তোমাদের বিধানসভা নির্বাচনের আগে 26 বিধানসভা নির্বাচনের আগে যদি বেকারদের নিয়ে যেভাবে এত বছর ধরে সিনেমিনি খেলা হয়েছে, 17 সালে রিক্রুটমেন্টের পরে 7 বছর প্রাইমারি টিচার রিক্রুটমেন্ট নেই, SLST 10 বছর রিক্রুটমেন্ট নেই, আবার প্রাইমারি 10 বছর রিক্রুটমেন্ট নেই, অন্যান্য রিক্রুটমেন্ট সব বন্ধ, পুলিশ রিক্রুটমেন্ট 3 বছর বন্ধ। যদি এই রিক্রুটমেন্ট এভাবে বন্ধ করে রাখে, তাহলে তোমরা অন্য দলকে বেছে নাও, আমি অনুরোধ করবো ব্যক্তিগতভাবে। শফিক বলছো, মিষ্টি কি বলছো, আর আমাদের কিছুই লাভ নেই। আচ্ছা, সবাই চোর, এই চোরে চোরে মাস্ত চোর। আচ্ছা, মিষ্টি বলছো, আচ্ছা শুনুন, সরকার এর কিছু যায় আসে না। দেখো ব্যাপারটা আমি বলি, আমি তোমাদের 23 স্টেট নিয়েও 23 স্টেটের
সংঘাতে মুখ্যমন্ত্রী মমতা বন্দ্যোপাধ্যায় সরাসরি নজর রাখবো সেদিকে।
এবং অন্যান্য অফিসাররাও আছেন, তাদের সকলকে আমার অনেক অভিনন্দন এবং ধন্যবাদ। যতক্ষণ কাজটা সম্পূর্ণ না হচ্ছে ততক্ষণ কিন্তু সদা জাগ্রত হিসেবে আমাদের মাথায় রাখতে হবে। প্রতি বছরই আমরা চেষ্টা করি
আমি বলতে চাই, নো পলিটিক্স। আজকের আমরা যে বিষয়ে আলোচনা করব,
না অবশ্যই খারাপ লাগাটা স্বাভাবিক, এটা অস্বাভাবিক কিছু না। না মোট সেটা 100%।
শিক্ষকদের নেতা হিসেবে দাঁড়িয়ে আছে, সমাজের মেরুদণ্ড শিক্ষকরা।
একদম
যে বাইশরা যদি তুমিও জানো, এটা আমিও জানি, এই বর্তমান পরিস্থিতিতে একবার যদি নিয়োগ হয়ে যায়, পরবর্তী নিয়োগ 5 বছর পর হবে। তুমিও জানো, আমি জানি। আজকে যদি আমরা আমাদের স্টেট যারা পাস করবে, তাদের কি চোখের জল নেই, তাদের কি কান্না নেই, তাদের মা বাপ নেই?
সেটা 100% নয়। তোমাকে একটা কথা বলি, দেখো 23 স্টেট অবশ্যই 23 স্টেট যুক্ত হবে, কারণ আমি
এখন পশ্চিমবঙ্গের বুকে শিক্ষকদের মুখ, সে ভুল বোঝাচ্ছে কোনো ছেলে মেয়েদেরকে, সে ভবিষ্যতে শিক্ষক হবে।
একদম
সে ভবিষ্যতে শিক্ষক হবে, সে প্রাইমারি ছেলেদেরকে পড়াবে, সে সমস্যাটা তুলে তুলবে, সে মানুষকে বোঝাচ্ছে। এবং তুমি জানো, পরশা দিকে আমাদের নাম উল্টো পাল্টা করে এসছে।
পরশা দিকে? আচ্ছা, তুমি 23 স্টেটের অ্যাডমিন, তাই তো? আচ্ছা, তোমার নাম কি? আচ্ছা,
বারবার এটা বুঝিয়েছি যে হয় একসঙ্গে আসো, একটা বড় ভ্যাকেন্সি চাই আমরা, 50,000 নয়, আমরা 1 লাখ ভ্যাকেন্সি চাইবো। একটা কথা বলছি, 23-এর যদি 8,000 ছেলে পাস করে, কয়েকবার বলছি, তার মধ্যে 2,000 অলরেডি পুরোনো ডেটে পাস করে আছে, ছেলে 2,000। এবার যদি আমি পর্যটকে বলি আপনি 22 থেকে 8 করছেন, আমাকে 10,000 এক্সট্রা আরো ভ্যাকেন্সি দিন, তাহলে ওই যে বাকিতে 8,000টা থাকবে, ওটা কাদের লাভ ভাই? বাই স্টেটের লাভ।
অবশ্যই সেটা 100%।
এটা বিদেশ দেখা বুঝেছি। আমাদের তো প্রেস
ক্যান্ডিডেট 1000 থেকে 1500 তার বেশি হবে না, তাহলে লাভটা কার হতো? যদি আমরা এটা বলতাম যে 22-23 একসঙ্গে চলে, আপনারা দুটোতে একসঙ্গে নিচ্ছেন, যেখানে আপনারা হয়তো 20,000 ভ্যাকেন্সি দিতেন, আমাদের বলছি 20 থেকে 25 বেশি ভ্যাকেন্সি আসবে না, আপনারা সেখানে 35 ভ্যাকেন্সি দিন, চাপ দিতে পারতাম না ভাই?
অবশ্যই অবশ্যই 100%।
এরকম করে কোনোদিন ইন্টারভিউ সারতে পারবে
না না, এরকম কোনো ইন্টারভিউ পসিবল না।
আমি আমরা সমবয়সী, তোমার এইচএস কত নাম্বার 14তে, তুমি যখন 28 বলবে পরে বলবে, তোমার ভিডিওগুলো দেখে কিন্তু পড়ছে না, এটাই তো আমার কথা। কারণ ওর কথা শুনে তো কিছু কিছু অনেক ছেলে আছে না ভাই।
আচ্ছা শোনো আগে কথা বলি। দেখো আমি বিদেশ দেখে তোমার একটা প্ল্যাটফর্ম দিয়েছি বলার, তো তুমি তোমার অভিমত, আমি তোমাকে একটা প্ল্যাটফর্ম দিতে পারি আমার এই চ্যানেলে সরাসরি লাইভে, তুমি বলো। আচ্ছা না 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 না, আমি দেখো, আমি তোমার ফুটেজ খাওয়ার কথা বলছি না, ব্যাপারটা কি বলো, দেখো ব্যাপারটা সোশ্যাল মিডিয়া যতক্ষণ না পর্যন্ত স্টেট আলোড়ন না ছড়াবে, ঠিক আছে, স্টেটে যতক্ষণ না সজাগ হবে। যেমন দেখো 22 স্টেটের এই আমি যখন বিদেশ দেখে নিয়ে ভিডিওটা করেছি, ঠিক আছে, ভিডিওটা করার পর কিন্তু 22 স্টেটের অনেক শিক্ষার্থীরা খুব খুশি, ঠিক আছে, আবার 23 স্টেটের শিক্ষার্থীরা কিন্তু কিছুটা হলেও ডিমোটিভেশন হয়ে যাচ্ছে। তো তুমি যদি তোমার কোনো বক্তব্য থাকে তুমি বলতে পারো, তোমার যদি কোনো অভিযোগ থাকে তো সবাই মিলে মিশে মানে তুমি 22 স্টেটকে বার্তা দিতে পারো যে আমরা একসঙ্গে তার লড়াইটা করি। হ্যাঁ, তুমি অ্যাপ্লিকেশনের সঙ্গে আলোচনা করো, আলোচনা প্ল্যাটফর্ম তৈরি করো। না না, আমার কাছে কোনো বাধা নেই, আমার কাছে সবাই শোনো।
তুমি যেটা করছো তাতে পর্ষদে দিলাম, সরকারে দিলাম, তুমি একসঙ্গে প্ল্যাটফর্ম তৈরি করার চেষ্টা করো। আচ্ছা বলো তো, আজকে 22 স্টেট কতদিন হয়েছে বলো তো? 22 স্টেটের হাতে যা টাকা আছে, যা লোক আছে, কবে ইন্টারভিউ নোটিশ চলে আসতো ভাই? যদি ঠিকঠাক পথ গাইড করতে এর পেছনে লাগবো, ওর পেছনে লাগবো, একটা লোক নিজের ইন্টারভিউ নোটিশটা আগে আরো টাকা করতে ইন্টারভিউ দিও।
তোমার কথার সঙ্গে দেখো আমি আচ্ছা দাদা শুনতে পাচ্ছ? আমরা লাইভে আছি এখন। তো প্রথমেই দাদা তোমাকে আমাদের এই ইউটিউব পরিবারে, অর্থাৎ আমাদের এই মিঠুনদার কোচিং সেন্টার এবং ইংলিশ উইথ মিঠুনদার দুটো চ্যানেলে সরাসরি সম্প্রচারিত হচ্ছে। প্রথমেই আমাদের পরিবারে তোমার মূল্যবান সময় দেওয়ার জন্য অনেক ধন্যবাদ এবং ভালোবাসা। আমাদের এই ইউটিউব চ্যানেলের পরিবারে যত সদস্য আছে, শিক্ষার্থী ভাই বোনেরা যারা আছে, সকলের তরফ থেকে তোমার প্রতি যথেষ্ট ভালোবাসা, এবং তোমার মানে তুমি অনেক ব্যস্ত মানুষ, আমাদের জন্য পরিশ্রম করছো, এত ইয়ে করছো। তো প্রথমে জাস্ট তুমি 2 লাইন বলো, তারপরে আজ তোমার জন্য দেখো আমার প্রশ্ন না, তোমাকে আজ পেয়েছি, আজ সহজে ছাড়বো না। তুমি বলেছিলে যে বেশি সময় দিতে পারবে না, তারপরেও দেখো তোমার জন্য কিন্তু প্রশ্ন আমরা রেডি করেছি, আমার শিক্ষার্থী বন্ধুদেরই প্রশ্ন। তো এখানে খোলামেলা উত্তর হবে, তুমি তোমার মন থেকে যা আসে প্রশ্ন উত্তরগুলো দিয়ে তারপরে বিদায়, তার আগে ছাড়ছি না। তো প্রথমে কিছু বলো তুমি, তারপরে আমরা শুরু করবো।
প্রথমে বলবো আমাদের মিঠুনদাকে ধন্যবাদ দেবো আমরা একটা প্ল্যাটফর্ম তৈরি করার জন্য। পড়াশোনার পাশাপাশি টিউশনির পাশাপাশি যেভাবে একটা ইউটিউব চ্যানেল সবার সামনে সঠিক খবর সবার আগে দেওয়ার চেষ্টা করছে, সেটা দেখে খুব ভালো লাগে। এইভাবে এগিয়ে আসতে হবে। আর এইটুকুই।
ঠিক আছে, তো বিষয়টা হচ্ছে দেখো, প্রথম বিষয়টা হচ্ছে বিশেষ করে 22 স্টেট পাস যারা আছে তারা তো বঞ্চিত, তারা বিভিন্ন দুশ্চিন্তার মধ্যে আছে, তো তাদের মনে অনেক হাজারো প্রশ্ন। সেই প্রশ্নের মধ্যে আমি যখন তোমার সঙ্গে যোগাযোগ করেছি, আর আমি প্রথমেই এটা ক্লিয়ার করে দিই, এটা কিন্তু বিদেশ দা বলেনি, আমি নিজে থেকে বিদেশ দাকে বলেছিলাম দাদা আমি সরাসরি তোমার একটা ইন্টারভিউ নিতে চাই। তো বিদেশ দা আমাকে সময় দিয়েছে, তার জন্য অনেক ধন্যবাদ। আর এই প্রশ্নগুলো আমার চ্যানেলে যারা রেগুলার ভিডিও দেখে তাদের থেকেই এই প্রশ্নগুলো নেওয়া। তো কিছু প্রশ্ন একটু কঠিন, কিছু প্রশ্ন একটু সহজ, সব মিলিয়ে আছে। তো প্রথম যেহেতু আমাদের 12 তারিখে যে ধর্ণা মঞ্চের আয়োজন করা হয়েছে, যেটা অনেক চেষ্টা করে, তো সেটা নিয়ে একটু বলো, সেটা নিয়ে অনেকের প্রশ্ন আছে, সবাইকে যেতে হবে কিনা, কি বিষয়টা, এটা কিন্তু অনেকেই এখনো ক্লিয়ার না যে ওই দিন কি সবাইকে যেতে হবে না, বিষয়টা মানে কি বিস্তারিত, এটা একটু জানতে চাই।
দেখুন, আমরা 10-11 ওই 3 দিন ধর্ণা চেয়েছিলাম, কিন্তু যেহেতু মাধ্যমিক পরীক্ষা, তো সেই অনুযায়ী আমাদের কিন্তু ওই 12টা থেকে 5টা পর্যন্ত ওই 11 তারিখে সকলকে আসলে অনুরোধ রইল। পাবলিশার যেহেতু কোনো অসুবিধা নেই, প্রত্যেকে আসুন, অন্তত আমাদের অস্তিত্বটা মুখ্যমন্ত্রীর সামনে, মাননীয় মুখ্যমন্ত্রীর সামনে তুলে ধরি। প্রত্যেকে আসুন, প্রত্যেকটা জেলা, এই জেলা কোচবিহার থেকে কাকদ্বীপ, এই জেলা প্রত্যেক 22-এ রাজপথে থাকি প্রতিদিন।
আচ্ছা, আমি এর মধ্যে আরো একটু বলে রাখতে চাই, যারা সরাসরি লাইভ এই ভিডিওটা দেখছো, তোমাদের যদি মনে কোনো প্রশ্ন থাকে সরাসরি তোমার লাইভ আমাকে প্রশ্ন করতে পারো, আমরা সরাসরি বিদেশদার কাছ থেকে সেই প্রশ্নের উত্তর জেনে নেবো। তো তার মধ্যে আমার পরবর্তী প্রশ্ন ছিল যেটা, যে এই যে 11 তারিখে যে ধর্ণা মঞ্চের আয়োজন করা হয়েছে, এটা কোন জায়গাটা, প্রপারলি কোন জায়গাটা হবে, এবং এই ধর্ণা মঞ্চে কি কি পদক্ষেপ নেওয়া হচ্ছে?
এটা অ্যাকচুয়ালি আমরা তো ধর্নার জন্য যেহেতু বিধাননগর উত্তর থানা বিকাশ ভবনের সামনে বা করুণাময়ী বাস স্ট্যান্ডের পাশে যেটা আমরা চেয়েছিলাম, তো যারা পাঠিয়েছিলেন থানা থেকে, তারা ওই বিকাশ ভবনের আশেপাশের যে ম্যাপ, সেই ম্যাপেরই কনসেপ্ট নেই। তো সেই জায়গায় দাঁড়িয়ে বিচারপতি, মহামান্য বিচারপতি ওই পথটা আমার চেনা জানা বা বোঝেন, উনি একটা কয়েকটা জায়গায় কথা বলছিলেন। তবে শেষ পর্যন্ত ওই সেন্ট্রাল পার্কের পাশে বিকাশ ভবন থেকে মুখ্যমন্ত্রী সম্ভবত তার বাসভবনের পাশে বিকাশ ভবনের খুব কাছাকাছি একটা প্রশ্ন, প্রথম কাছাকাছি কথা বলছিল মেট্রো কাছে। তো পুলিশ আমাদেরকে যেতে বলেছে যে একটা তোমাদের কোন জায়গাগুলো তুমি সব একটু একদিন আগে এসে আমাদের সাথে একটু কথা বলো, তাহলে সেই জায়গাটা আমরা পরিষ্কার পরিচ্ছন্ন করে রেখে দেবো। তো আমাদের যে 5 ঘন্টা, আমরা শুধু 12টা থেকে ধরছি না, যেহেতু দূর বাড়ি, অনেকে আগে থেকে চলে আসবে। তো আমরা 10টা থেকে কিন্তু শিয়ালদায়, 10টার দিকে আমরা শিয়ালদায় কিন্তু জমায়েত হবো, এবং 10:30টার মেট্রোটা ধরবো। শিয়ালদা মেট্রো থেকে 10:30টার মেট্রো কিন্তু ধরবো আমরা বিকাশ ভবনের উদ্দেশ্যে। যে যেখানে থাকবেন 10টার মধ্যে বা 10টা 20-র মধ্যে শিয়ালদায় আসবেন, শিয়ালদার থেকে একটা মেট্রো ধরবো আমরা। আর ওখানে যে কর্মসূচিগুলো আছে, আজকে আমাদের রাতে একটা টেলিগ্রাম মিটিং আছে 23টা জেলায়, উত্তীর্ণ যারা আছে গ্রুপে। তো আমরা দেখাতে চাই যে কেউ MA, কেউ MSc, কেউ DLED একসাথে করেছেন, কেউ অনেক মানে তো সবাই আমরা কেউ চায়ের দোকান, কেউ চপের দোকান, বিভিন্ন ভাবে মুখ্যমন্ত্রীর সামনে তুলে ধরার চেষ্টা করবো যে 2 বছর প্রশিক্ষণ, তারপর টেট উত্তীর্ণ, তার মধ্যে MA পাস করা, তার মধ্যে অনার্স পাস করা, এইসব এত ডিগ্রি করে এখন চায়ের দোকান করবো ভালো জ্ঞানের জন্য, সবার তো একটা স্বপ্ন থাকে, এগুলো আমরা তুলে ধরার চেষ্টা করবো।
যেহেতু 12 ফেব্রুয়ারি বাজেট পেশ আছে আমাদের মাননীয় মুখ্যমন্ত্রী, সেহেতু এই দিনটাকে বেছে নেওয়া ব্যক্তিগতভাবে মনে করি খুবই একটা সুন্দর দিন, কারণ কিছুটা হলেও প্রভাব যদি কোনোভাবে যদি দৃষ্টি আকর্ষণ করা যায় আমাদের মাননীয় মুখ্যমন্ত্রীর কাছে, তো আমার ব্যক্তিগত এটা অনুরোধ থাকবে যে যত মানে নিউজ চ্যানেল আছে, সমস্ত নিউজ চ্যানেলের কাছে এই বার্তা পৌঁছানো, যেন তারা কভারেজটা করে অন্তত ওই যে সময়টুকু, এই সময়টুকু সবাই যোগ্য, যারা পাস করছে সবাই যোগ্য, বা যারা পাস করবে, ঠিক আছে,
চাকরি সবার প্রয়োজন আছে, কারণ বাংলায় আর প্রশ্ন হচ্ছে পরবর্তী হওয়ার জন্য যে প্রশ্নটা, সেটা হচ্ছে একটু ক্রিটিক্যাল প্রশ্ন, যে বিষয়টা হচ্ছে এই আমাকে অনেকেই শিক্ষার্থী বন্ধুরা, আমি তোমার কাছে সরাসরি জিজ্ঞাসা করব, এই যে ডিএলএড অ্যাসোসিয়েশন, আমি সত্যি কথা বলছি, এটা একদম না আমি বিদেশিদের সঙ্গে সরাসরি কথা বলছি বলে আমি তার প্রশংসা করছি তা নয়, এমনটা নয়। এখনো পর্যন্ত ডিএলএড মানে অ্যাসোসিয়েশনের তরফ থেকে আমাদের কারোর সঙ্গে কোনো যোগাযোগ তো করেনি, তারা কোনো রকম ভাবে কিছু করেনি। যদি কিছু আমরা সামনে যে কোনোই, সেটা যে ধর্ণা মঞ্চ হোক, আন্দোলন হোক, এটা কিন্তু আমরা দেখেছি ডিএলএড যে ঐক্য মঞ্চ, তারাই কিন্তু এখানে মানে প্রধান ভূমিকা গ্রহণ করেছে। আমি কাউকেই ছোট করছি না বা কাউকে আমি ইয়ে করছি না, কিন্তু আমার অনেকে শিক্ষার্থীরা প্রশ্ন করে যে ডিএলএড অ্যাসোসিয়েশন আর ডিএলএড ঐক্য মঞ্চ এক হয় না কেন?
দেখুন, ডিএলএড বাঁচাও, পশ্চিমবঙ্গ ডিএলএড ঐক্য মঞ্চ, অল বেঙ্গল ডিএলএড অ্যাসোসিয়েশন, আবার শুধু ডিএলএড অ্যাসোসিয়েশন, সোশ্যাল মিডিয়াতে এরকম প্রচুর গ্রুপ আছে, তো এরকম প্রচুর অ্যাডমিনও আছে আমাদের সাথে কথা বলছে। তো সবাই তো আমরা একই, যারা দিনের শেষে ফোন করে, দিনের শেষে ফোন করে দাদা কি খবর, দিনের শেষে বলে এটা কি খবর, এটা কি বুঝতে পারছি না, ওনাকে গেছে হঠাৎ দিয়ে বলবে এটা কি হলো। তো এরকম কিন্তু অনেক, তেমন একদল আছে অনেকে যে মানে বিভিন্ন যে আমাদের এই যে একাডেমিক সমতা মঞ্চ, এরকম বহু মঞ্চ কিন্তু আছে। তারপর আপনার প্যারাডিসাইডের সংগঠন, তো তাদের আলাদা আলাদা ফেসবুক গ্রুপ আছে, হোয়াটসঅ্যাপ গ্রুপ আছে, তারা কিন্তু দিনের শেষে কথা হয় প্রত্যেকের সাথে। আমার তো মনে হয় না কেউ সবাই তো একই সাথে চলছে, আলাদা কোনো গ্রুপ আছে, অস্তিত্ব আছে বলে বর্তমানে আমি অন্তত দেখছি না। তারা আমাদের সাথে কথা হয় সবার সাথে, কম বেশি কথা হয়, আমি তো চিনি না, তারা পরে দেওয়া আপনার সংগঠনের পক্ষ থেকে এসে ঠিক আছে বলো, তবে এইটুকুই, আলাদা করে কোনো গ্রুপ আমি দেখতে পাচ্ছি না।
তবে দাদা আমি এটুকু বলবো আমাদের চ্যানেলের তরফ থেকে এবং সমস্ত শিক্ষার্থী বন্ধুদের তরফ থেকে 22 স্টেট পার যারা আছে, মানে তুমি এবং তোমার যারা সহকর্মীরা আছে, তারা যেভাবে নিরলস ভাবে পরিশ্রম করে যাচ্ছে, এই পরিশ্রম কিন্তু অন্য কোনো গ্রুপ কেউ কিন্তু করছে না। তোমরা যেভাবে নিরলস ভাবে পরিশ্রম মানে চলছে, এই পরিশ্রম কিন্তু অন্য কোনো গ্রুপ বা কেউ করছে না। এই নিঃস্বার্থ পরিশ্রম করার পরেও হয়তো অনেক সময় অনেকে হয়তো কটু কথা শুনতে হয়, এটা আমি দেখেছি, শুনতে হয়, কিন্তু তারপরেও নিঃস্বার্থ ভাবে যে মানে তুমি পাশে দাঁড়িয়ে আছো এই 22 স্টেটের পাশে, তার জন্য 22 স্টেট সর্বদা সারা জীবন চাকরি পাওয়ার পরেও তোমার সেলুট করতে হবে এবং তোমার কথা মনে রাখতে হবে। হয়তো আজ হয়তো তোমাকে ভুল বুঝে হয়তো অনেকেই অনেক কিছু বলছে, কিন্তু ভবিষ্যতে তোমার পাশে একটা সময় মনে পড়ে, চাকরি পাওয়ার পরে একটা সময় কিন্তু তখন বলবে যে বিদেশ যাওয়ার জন্যই হয়তো চাকরিটা এই 5 বছর পরের জায়গায় 4 বছর আগে পেয়েছি চাকরিটা। আর না হলে যদি বিদেশ যদি বা তার টিম যদি ভাবে লেগে না থাকতো, তাহলে এই চাকরিটা হয়তো আরো 10 বছর পিছিয়ে যেত বা 5 বছর পিছিয়ে যেত। আমার লাইভে কমেন্টে ভরে যাচ্ছে, তুমি ওই প্রশ্ন পরে আমার কাছে যেগুলো চার্ট আছে সেইগুলো আগে করবো, তারপরে অন্য প্রশ্ন। আচ্ছা, প্রশ্ন হচ্ছিল পরবর্তী প্রশ্ন। দেখো আমি যতই ওদের বলি বা আমার শিক্ষার্থী বন্ধুদের বলি, আচ্ছা আমি তুমি করেই বলছি, তুমি করে বলতে বলতে অভ্যাস, তোমার সঙ্গে তুমি করে বলছি, বলো, আর তোমার সঙ্গে তুমি করে বলেছি, এখন আবার আপনি করে বলছো, এখানে কেমন মিলে যাচ্ছে। আচ্ছা, তো আমি বললেও ওরা তোমার মধ্যে শুনতে চাই, যারা 82 পাস করেছে, যারা ওবিসি হোক, এসসি হোক, এসটি হোক, যারা 82 পাস করেছে, তাদের কি হবে যদি এই যে সুপ্রিম কোর্টের যে জাজমেন্টটা রয়েছে, কারণ আমাদের কোর্টের জাজমেন্টটা ছিল যে অলরেডি যারা ইনক্লুডিং আছে তাদের কোনো প্রবলেম হবে না, তোমার মতামতটা কি এখানে? রিজার্ভেশন যারা আছে, রিজার্ভেশনের কথা বলছি, ওবিসি ব্যাপারটা, ওবিসি ব্যাপার।
দেখুন, কলকাতা হাইকোর্টের যে অর্ডার, সেই অর্ডারটা যদি ভালো করে কলকাতা হাইকোর্টের যে অর্ডার অলরেডি বেনিফিট যারা অলরেডি পেয়ে গেছে, তাদের ক্ষেত্রে কিন্তু কোন সমস্যা হবে বলে মনে হচ্ছে না আপাতত যেটা দেখছি। আর আমার তো ব্যক্তিগত ভাবে মনে হয় যে কোনো অসুবিধা হবে না আগামী দিনে। সুপ্রিম কোর্টের দিকে তাকিয়ে থাকতে হবে এখন থেকে। আমরা যদি হেরে যাবে অনেকে নিয়ে, আমিও এই প্রশ্নটার সম্মুখীন আমি হয়েছি প্রচুর। তো অনেকে কিন্তু খুব চাপা টেনশন অনেকে কাজ করছে, কারণ কোয়ালিফাই কেউ করতে পারছে না, কারণ 2022-এ হয়তো কোয়ালিফাই বেশি সংখ্যক আছে, কিন্তু যে অনুপাতে বসেছিলেন সবাই পরীক্ষা সেই অনুপাতে কি কোয়ালিফাই ছিল? হয়তো কোশ্চেন চলে গেছে অনেকে বলছে। তো বিদেশি যারা পেয়েছে তারা কিন্তু একটা বাস্তব পেয়েছেন না। আসলে আমি একটা কথা বলবো, সেই কথাটা হয়তো খুব খারাপ ভাবে সবার লাগবে। আমার ব্যক্তিগতভাবে মনে হয় সুপ্রিম কোর্ট থেকে তাকিয়ে থাকা উচিত, সমস্যা হবে বলে মনে হয় না।
আচ্ছা, তারপর তোমাদের প্রশ্ন ছিল যে বিএড যারা মানে যারা জিএলএড করেছে 21-23 সেশনে 22-24 সেশন এরা বসতে পারবে কিনা?
না, 21-23 অলরেডি বসতেই পারবে।
বসতে পারবে 21-23। 22-24
ওদের তো মার্কশিটটা দিতে পারবে।
হ্যাঁ, মার্কশিটে দিতে পারে, কারণ ওরা বসতে পারছে।
ওদের পরীক্ষা হয়ে গেছে। হ্যাঁ, কারণ এদের যদি যদি রিক্রুটমেন্ট চালিয়ে দেওয়া হয়, তো 22-এর মতো সমস্যা যদি সামনে
আবার কেস হবে।
22-এর মতো আমার কেসটা হয়ে যাবে, আমার বিষয়টা। এই জন্য হয়তো 22-24 নোটিফিকেশনের মানে ইন্টারভিউ প্রসেসের মধ্যে আসতে পারে। তবে 21-23 কনফার্ম।
21-23 কনফার্ম। 21-23 কনফার্ম। যারা বিএড পাস যারা বিএড করেছে, বিএড করে যারা পাস করেছিল, এই প্রশ্নটা সবার মনে বা সবার ইয়ে রয়েছে, যারা বিএড কমপ্লিট করে টেট পাস করেছিল অনেকেই বলছে ডবল ডিগ্রি যারা বসতে পারে। এখন প্রশ্ন অনেকেই যে এটা নোটিফিকেশনের আগে যারা ডিএলএড করা ছিল এবং বিএড ছিল তাদের আপডেট করার সুযোগ পাবে। আর অনেকেই বলছে যারা বিএড পারে না, বিভিন্ন গ্রুপ দেখছে, আমাদের বিভিন্ন গ্রুপে আছে যারা অলরেডি টেট পাস করেছে বিএড দেখিয়ে, কিন্তু তাদের ডিএলএড ছিল না, পরবর্তীতে তারা ডিএলএড কেউ 21-23 সরি কেউ 22-24 কেউ 23-25 সেশনে ভর্তি হচ্ছে, বা 22-24 বা 21-23 সেশনে ভর্তি হয়েছে। তাদের 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 বিষয়টা
আমি এই কোশ্চেনগুলো বিএড বা মানে এইসব কোশ্চেনগুলো আমি মানে ফেসবুকেও বড় বন্ধ করে দিয়েছি।
আচ্ছা আচ্ছা।
কারণ আমি একটা কথা বলবো, এটা নিয়ে আবার কন্ট্রোভার্সি তৈরি হবে।
আচ্ছা,
কারণ সবাই তো দাদা ভাই বোন দিদি সবাই এই যারা কোয়ালিফাই করেছে, এসএসসি হয় না, দীর্ঘ বছর এসএসসি হয় না, এসএলএসটি হয় না, আমার মানে 8 বছর পর এখন নিয়োগ হচ্ছে। তো সবাই কিন্তু একটা চাপা টেনশন কি, প্রত্যেকেরই যুগ বাড়ছে, বয়স বাড়ছে, নিজেকে স্টাবলিশ করতে পারছে না, একটা ডিপ্রেশনের মধ্যে আছে। তো সবাই চাইছে রিক্রুটমেন্ট প্রসেসে আসার জন্য।
সেটা 100 বার, এটা 100 বার।
আমি ব্যক্তিগতভাবে চাই যে যারা অলরেডি যারা বঞ্চিত দীর্ঘদিন ধরে তারা নিয়োগ পাক। আর বিএড এর ব্যাপারটা এটুকু বলবো, মানে ব্যক্তিগতভাবে তো আক্রমণ করবেন না, তবে আমাদের 2022-এর টেট নিয়ে একজন 22-এর উত্তীর্ণ হিসেবে বলছি না, নর্মালি একজন বলছি, মানে আইনের দিক থেকে যদি বলতে ভাবেন আপনি বুঝতে পারবেন যে 2022-এর প্রাইমারি টেট দেওয়ার আগে একটা নোটিফিকেশন কিন্তু প্রস্তাব দিয়েছিল, বিএড বসতে পারবে কি পারবে না, সেটা আপনি পারলে কমেন্ট বক্সে দিতে পারেন। তো তারপরে কিন্তু সার্টিফিকেটটা ভ্যালিড কি ইনভ্যালিড সেটা কিন্তু নির্ভর করছে। এবার পরবর্তীকালে যারা ডিএলএড করছে অনেকে ডাইরেক্ট হয়তো বলছে আমি কর্মসংস্থানে দেখছিলাম যে হ্যাঁ পরবর্তীকালে ডিএলএড করলে তারা বসতে পারবে। তো দেখা যাক এনসিএল গাইডলাইন কি মানছে, সুপ্রিম কোর্ট কি বলছে।
ম্যাট 1594 কি 22-এর কাছে মাথা ব্যথার কারণ?
একদমই তাই। ম্যাট 1594 এটা সরকার আমাকে অলরেডি বলছিল। তো অলরেডি সেই কেসে আমরা অনেকেই জানেন যে বেশ কিছু কিন্তু চাকরি করছেন সেই নাম্বার দিয়ে। তো এই অর্ডারটা আসলে কিন্তু
বিপদ হয়ে যাবে,
কিন্তু বর্তমানে বড় বিপদ, একটা মহাসাগর তৈরি হয়ে যাবে। তারা ইউটিউবে দেখে নিতে পারে সার্চ করলে যে ডিভিশন বেঞ্চের যে অর্ডার ছিল সে মানে 2016 প্রশ্নপত্র মামলায়, সেখানে কিন্তু আইনজীবী কিন্তু বলেছে যে প্রায় 1 লক্ষের মতো কোয়ালিফাই করতে পারে নতুন করে, তো বেশি হলেও হতে পারে। তো এতে একটা পজিটিভ দিক আছে, সরকার আমাদের এগিয়ে আসছে দেখলাম যারা অলরেডি 2016 প্রশ্নগুলো অলরেডি চাকরি করছে, এই বিষয়ে কিন্তু অলরেডি কিন্তু সুপ্রিম কোর্টে কিন্তু বছর থেকে কিন্তু গেছে। আমি ইতিহাস এই মুহূর্তে বলছি না,
প্রশ্ন হস্তক্ষেপ করেছে।
তো যেটা যেটা বলবো তথ্য দিয়ে তো বলতে হবে। এই মুহূর্তে আমার মনে পড়ছে না, কিন্তু সরকারও চাইছে না যে প্রশ্ন বলতে গেলে কোনোভাবে, কারণ প্রশ্ন বলতে যদি হয় না পুরো সিস্টেম ভালো আছে করতে হবে।
নর্মাল নতুন করে হলো তো
2014 সালে কোনো কিছু নেই, তাহলে কি কার ভিত্তিতে ঠিক না হতে রাষ্ট্রে আছে কিভাবে কিছু করা নেই, তবে চলে কিছু করা থাকবে না। তাই আমাদের 2022 প্রাথমিকের উত্তীর্ণ অভিজ্ঞতা থাকতে হবে। ব্যাংকের এআই বিস্তারিত আছে, মানে বাংলাদেশের দেখছি না, তো এআই সবাই মিলে একসাথে আইন করে লড়াইটা করতে হবে।
আচ্ছা, আমার একজন শিক্ষার্থী বন্ধু কমেন্ট করে মানে প্রশ্ন করেছে, আমরা শেষমেশ 22টি নোটিফিকেশন, ইন্টারভিউ নোটিফিকেশন কবে পেতে চলেছি, বিদেশদার কি অনুমান?
নোটিফিকেশন তো অনেক আগেই পাওয়ার কথা ছিল, নোটিফিকেশন অনেক আগেই পাওয়ার কথা ছিল, কিন্তু একটা কথা বুঝতে হবে 2022 রিক্রুটমেন্ট 2022 ওইটা আমরা অনেকের মধ্যে জানি না, তো সাংবাদিক বন্ধুরাও জানতো না, তো আমরা বলে 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 এখন যেটি প্রাইমারি রিক্রুটমেন্ট সম্পূর্ণ আলাদা। গতকাল একজন মহিলা আমাকে কল করছিলেন একটা ডিপার্টমেন্টে সরকারি, বাজে তথ্য নিয়েছিলেন যে আমাদের দাবিগুলো কি, সে আমি বলছিলাম যে এই ব্যাপারটা বলে আপনাদের দেখা কথা হচ্ছিল, তো আমাদের এটা তো ভুল হচ্ছিল, এটা রিক্রুটমেন্ট নিয়ে আসলে বলে তো যেটা বলছিলাম আসতে পারে কিন্তু আমাদের আমি আমাদের বলবো 2025 রিক্রুটমেন্ট হয়েছে, বছর হয়েছে, এই ঘোষণাটা কিন্তু পরে আসছে, কিন্তু আমাদের কাছে এই ঘোষণাটা কিন্তু আগে নোটিফিকেশন তো যেহেতু কথা আপনি ওবিসি কথা মিলে 3 দিনের মধ্যে দিয়ে দেবেন, কিন্তু আমার ব্যক্তিগত মনে হয় যে ওবিসি মামলা বেশ সমাজে নোটিফিকেশন আসবে বলে আমার মনে হয়। তো 2025 এর মধ্যে নোটিফিকেশন আসবে, আমি ইন্টারভিউ প্রসেস চালু হয়ে যাবে, এটা কনফার্ম আমি বলে দিলাম। হ্যাঁ, 25 এর মধ্যে মানে আমার এই যে কথা বলছি এগুলো সব আমার ব্যক্তিগত মতামত,
বুঝতে পারছি,
মানে বিভিন্ন দপ্তরে গিয়ে বিভিন্ন আধিকারিকদের সাথে কথা বলে, এমনকি আপনারা তো দেখিয়েছেন যে সেখানে বলছেন যে ভোটের পর পরই হবে, কিন্তু ভোট হয়ে গেল বিয়ে হয়, এখন বলছেন ওবিসি মামলা মেটার সাথে সাথে 3 দিনের মধ্যে নোটিফিকেশন আসবে, তো এইসব কথার উপর ভিত্তি করে বলতে হয়। যাই হোক, যেহেতু অলরেডি সামনে বিধানসভা ভোট 26 সালে তো ফেব্রুয়ারি মার্চ
দিকে ভোট,
যার ফলে নিয়মটা কিন্তু এবার নোটিফিকেশন দেবে, নিয়ম তো কেটে নোটিফিকেশনটা পুরো আগে নতুন ডেটের জন্য নোটিফিকেশন দেবে, এই হতে পারে।
মানে রিক্রুটমেন্ট 26 এর ভোটের আগে কি কমপ্লিট হবে?
একদমই হতে হবে।
আচ্ছা, আর একটা প্রশ্ন, 23 সালের রেজাল্ট, 23 সালের রেজাল্ট
23 এর রেজাল্ট কথাটাও কিন্তু আমি ফেসবুকে বলা বন্ধ করে দিয়েছি। দেখুন, আমাদেরও তো একটা সংগঠন আছে 2022 এখন ফেসবুক, সবাই চায় যে কম্পিটিশন।
আমি জানি যে দাদাকে এইভাবে প্রশ্ন না করলে এই প্রশ্নের উত্তর পাবো না, ঠিক আছে, আমাকে বলেছে প্রশ্ন করতে, আমি আমার কাজ প্রশ্ন করার, আমি করবোই, ঠিক আছে, এখন তুমি কি উত্তর দেওয়া দাও।
দেখুন, ব্যাপারটা হচ্ছে আমাদের 2022 প্রাথমিকের উত্তীর্ণ সবাই আমরা চাই যে আমাদের কম্পিটিশন না বাড়ুক,
একদম না, অবশ্যই 22 তো অবশ্যই চাইবে 23 না আসুক, আর 23 চাইবে 22 আসুক।
প্রত্যেকে আমার জায়গায় যদি যে কোনো 23 পরীক্ষা দিয়েছে 22 পাস করতে পারেনি, সে কিন্তু আমার জায়গা হলে বলতো যে না আসে।
একদম একদম,
এর থেকে মাঝে মাঝে কিছু কিছু ব্যক্তিগত আক্রমণ হচ্ছে, এই জন্য আমি এই কথাগুলো বলা বন্ধ করে দিয়েছি। তবে লাস্ট 2 বার সভাপতির সাথে কথা বলে যেটুকু জেনেছি, এই কথাটাই বলেন যে তো আপনাদের কিঞ্চিত পাস করবে।
আচ্ছা,
কিঞ্চিত পাস করবে, না করবেন না,
মানে সভাপতি
মশাই বলেন কিঞ্চিত, এই কথাটা কিঞ্চিত পাস করবে, কিঞ্চিত খুব ক্ষতি করবেন আমাদের। আমাদের এই জন্য কি ভ্যাকান্সি বাড়াবেন?
সব বাড়ির মালিকই চায় যে তাদের বাড়ি একটি প্রাসাদের মতন সুন্দর দেখা, যা উজ্জ্বল হবে আবার মজবুত। আর এই স্বপ্নগুলো পূর্ণ করতে বাংলার সিমেন্ট নিয়ে এসেছে একটি নতুন প্রিমিয়াম প্রোডাক্ট, বাংলার মার্বেল স্ল্যাগ সিমেন্ট, সলিড ব্রাইট হোমস। এর বিশেষ স্ল্যাগ ফর্মুলা আপনার বাড়িকে দেয় অতুলনীয় উজ্জ্বলতা। এতে থাকা সূক্ষ্ম কণাগুলি উন্নত সেটিং টাইমে সাহায্য করে। এর হাই গ্রেড স্ল্যাগ দেয় আপনার বাড়িকে মজবুতি স্থায়িত্ব দীর্ঘ সময় ধরে। এর লো হিট অফ হাইড্রেশন ক্র্যাকস হতে দেয় না। তাহলে আপন করুন বাংলার মার্বেল সিমেন্ট, আপনার বাড়িকে বানান আপনার স্বপ্নের প্রাসাদ। বাংলার মার্বেল সিমেন্ট ফর সলিড ব্রাইট হোমস।
তো আমার এইটুকুই বললাম। তো কিঞ্চিত পাস করবে এবং রিকোয়েস্টের শুনে বললেন যে এটা কিন্তু আপনারা আটকাবেন না বা আটকাতে ডিএসআর বললেন আপনারা আটকাতে পারেন না। তো সামনের দিকে প্রত্যেক বছর যেমন একটা ডেট একটা রিক্রুটমেন্ট হতো, সামনের দিন মধ্যে কিছু পরিবর্তন হতে পারে, এটা চেঞ্জ হতে পারে। আমি ডাইরেক্ট কিছু বললাম না, এবার আমরা বুঝে নিই। তবু এখন আমি আমার এই জায়গা থেকে বলবো 22 আলাদা রিক্রুটমেন্ট হোক। দীর্ঘ 5 বছর পর রাজ্যের ডেট হলো। আর যারা 23 পরীক্ষা দিয়েছিল, দেখুন আপনি বিচার করে দেখুন, ডিএলএড যারা পরীক্ষা দিয়েছে তারা কিন্তু 22 কিন্তু সুযোগ পেয়েছিল একবার। নতুন করে যারা ডিএলএড পাস করে যারা আছে তারাও কিন্তু না, সবাই কিন্তু 22 পরীক্ষা দিয়েছে। নতুন করে 23 কারা দিয়েছিল, 22 নেই ক্যান্ডিডেট কিন্তু 23 দিয়েছে। নতুন করে কিন্তু কোন ডিএলএড এর সেশন কিন্তু যুক্ত হতে পারেনি, দেখবেন ভালো করে। তো সেই জায়গায় নিয়ে আমার কথা বলছি। এবং অনেক বঞ্চিত ভাইরা রয়েছে, 22 পরিবারের হতে পারে, কোন কারণে হতে পারে, তারা 23 গিয়ে তারা পাস করার আশায় রয়েছে। তাদেরকে আমি মানে খারাপ ভাবে নিচ্ছি, মানে সেইভাবে বলছি না। কিন্তু আমি চাই 2022 সাল যেহেতু প্রত্যেক বছর বছর একটা করে ডেট, একটা করে রিক্রুটমেন্ট। 2014 সালে কেস করেছিল 2বার রিক্রুটমেন্ট, 3বার পেয়েছে ওরা। 2017 কিন্তু পেয়ে গেছে। এবারে 22 আমাদের পুলিশ সুবিধা একদিক থেকে সামনের দিনে একটা ডেট একটা রিক্রুটমেন্ট হবে। কিন্তু একবার যদি দুটো ডেট একবার রিক্রুটমেন্টের সুযোগ যদি পর্ষদ দিয়ে নেয়, সামনের দিনে 4টে ডেটে একটা রিক্রুটমেন্ট হবে। এটা আমি আপনি ইউটিউবে বলে মানে চ্যানেলে বলে গেলাম, আমি মিঠুনরা চ্যানেলে বলে গেলাম। 22 কেন বলছি, 23 বঞ্চিত করার জন্য নয়, 23 সুবিধা আগামী দিনে সুবিধার জন্য। যে 3-4 হাজার 5 হাজার 6 হাজার পাস করবে তাদের সবার রিক্রুটমেন্ট হতে পারে, এটা আমাদের রিক্রুটমেন্ট হয়। সেই কারণে বলছি, যদি একটা কেস একটা রিক্রুটমেন্ট হয়, সামনের দিকে ভাবেন আমাদের বেরিয়ে যাওয়ার সম্ভাবনা বেশি। আর যখন আমরা রাজি হয়ে যায়, এগ্রি হয়ে যায়, দুটো কেস একটা রিক্রুটমেন্ট, পরে দেখবেন 3টে ডেট একটা রিক্রুটমেন্ট, তারপর দেখবেন 4টে ডেট একটা রিক্রুটমেন্ট, তারপর দেখবেন 5টা ডেট একটা রিক্রুটমেন্ট। এটা কিন্তু চেঞ্জ হয়ে যাবে। এই কারণের জন্য আমাদের বলা।
সবচেয়ে বড় প্রশ্ন, যারা 22 পাস করে আছে, মানে ডিএলএড বৈধ ক্যান্ডিডেট যারা পাস করেছে, তাদের এখন মনে ভয় ধরেছে 17 গেটের যে প্রশ্নবুল মামলাটা, 2022 যে প্রশ্নবুল 2022 যে প্রশ্নবুল মামলাটা, সেখানে ভয় পাচ্ছে যে নম্বর কমবে কিনা। যারা কাটা BAISHAKHI পাস করেছে তাদের সংশয় রয়েছে যে নম্বর একটা বড় প্রশ্ন।
আইনি বিষয় তো এইভাবে বলা এইভাবে না, তবে আমি ব্যক্তিগতভাবে বলতে পারি আইনি যে রায় পাবো সেটা তো বাঙালিতে নিতে হবে নর্মাল আদালতে, কমবে না।
আমি এই মতামত
অলরেডি যারা সার্টিফাইড করেছে, সরকারকে সার্টিফাইড করা হয়েছে, কোনদিন আমরা দেখিনি যে নাম্বার কমে গেছে। আমার ব্যক্তিগতভাবে আমার অভিজ্ঞতা আমি কোনদিন দেখিনি যে সার্টিফাইড করলো BAISHAKHI, 1 নম্বর কমে গেল বলে তাকে আউট করে দিল, মানে 81 করে দিয়ে ফেল করে দিল, এরকম কোনো নজির নেই।
এখনো পর্যন্ত হয়নি, আমাদের পশ্চিমবঙ্গে এখনো পর্যন্ত এরকম ঘটনা ঘটেনি।
না, ওখানে চাপা টেনশন সবার কাজ করে যে BAISHAKHI এখন কাটে আসে কি হবে, অনেক ঘুমাতে পারে না, হয়তো চ্যানেল অনেকে দেখবে, এমন অনেকে আছে ঘুমোতে পারে না যে কি হবে কি হবে।
সে তো অবশ্যই, সে তো আছে। যোগ শেষমেশ আমার আর অল্প একটা প্রশ্ন, মানে ছোট একটা প্রশ্নটা হচ্ছে, কোন 2022 ডেট যারা পাস করে আছে তাদের শেষমেশ এখন করণীয় কি? অনেকে প্রশ্ন করে, দাদা আমি কি ডেট পরীক্ষার জন্য প্রস্তুতি নেবো, ইন্টারভিউর জন্য প্রস্তুতি নেবো, না আমি কি করবো? এই প্রশ্নটা কিন্তু অনেকের মধ্যে রয়েছে, সংশয় রয়েছে, দুবিধায় রয়েছে যে 18 তারিখে যদি মিটে যায় কেসটা, তাহলে আমাদের শিক্ষামন্ত্রী আমাদের গৌতম পাল যে কথা বলেছেন সেই কথা মতো কি ইন্টারভিউ নোটিশ আসবে? যদি না আসে আমি এদিকেও প্রিপারেশন নিচ্ছি না, ওদিকেও এর চেষ্টা করছি, একুল একুল দুকুলি যাবে না নাকি? এই ভয় কিন্তু অনেকের কাজ করছে।
একটা কথা বলবো, বাড়িতে বড় আর রাস্তায় লড়ো, বাড়িতে বড় রাস্তায় লড়ো, এই কথাটা এখন দেখুন আমাদের কথা এই এক সময় সময় চলেছে কত বসে যাচ্ছে, এক সময় কিন্তু 5 জন নিয়েও বিরাজমানের সামনে বসে পড়েছিলেন রাজনীতিতে। তখন কিন্তু এত ঐক্যবদ্ধ ছিল না, ইউটিউবে কিন্তু এত বাইকেট নিয়ে বড় হতো না, কিন্তু এই জায়গাটাতে কিন্তু আমরা যথেষ্ট সংঘবদ্ধ। আমরা যদি প্রত্যেকে কাজ করে নামতে পারি, দেখুন আজকে আমরা সবাই কিন্তু জেনে গেছি মুখ্য
Was it pending for the CPI?
But I just wish to take only a couple of minutes, my lord. I've already filed my written submission. Only 4 paragraphs from your judgments on, my lord, 4 aspects which are bothering your lordship, my lord. Number 1.
You are supporting the petition or opposing?
No, I'm saying that the entire process has to go because the identification is impossible and the High Court was fully right. Only 2-3 things, my lord. There is the judgment compilation, my lord, which is the email, and there is also a hard copy which I have given. My lord, first judgment is Krishna Yadav, where, my lord, your lordships have held that the entire process must go where the CBI inquiry was ordered. Your lordships accepted the report. That's, my lord, the first judgment in the compilation. That 94, my lord, Justice Bone's judgment, my lord, as your lordship there was. And, my lord, your lordships have been shown this judgment. I'm not going to it again. Second judgment, my lord, of CHATTERJEE. That's the principle, my lord, where gross illegalities have taken place, even gross illegalities have taken place, then, my lord, there is no question of any grant of personal hearing. That is, my lord, CHATTERJEE principle, my lord, repeated again. Now, my lord, I one paragraph which I want to read, my lord, is from Tanvi Sarwar, which your lordships have seen. And we see the third judgment, my lord. This was the entrance test for medical examination, my lord, the recruitment of seats. Kindly come to para 20 of this judgment, my lord, which is that compilation, page number. My lord, this is the Tanvi Sarwar 2015 6 SCC 573. Kindly come to, my lord, para 20. And, my lord, it is between just 3 lines below placitum E. The sentence starts, my lord, we are conscious of the fact. I just want to read with your lordship permission. Read it and para 20. I'm giving you the citation. I've emailed it to you.
Citation.
2015 6 SCC 573. Kindly, my lord, 10th line from top. Just 1 line above placitum C. In the middle, the sentence starts, we are conscious. My lord, your lordship got it? Just permit me to read these 10 lines because that would have some bearing for your lordship kind consideration. अरे उनको judgment का आपको दे दो ना citation.
Cited by me also. That's what
Great, please.
Yes, please.
We are conscious of the fact that every examination being conducted by human agency is likely to suffer from some shortcomings, but deliberate inroads into its framework of the magnitude and the nature, as exhibited in the present case, demonstrate a deep-seated and pervasive impact, which ought not to be disregarded or glossed over, lest it may amount to diversity of a proclaimed mechanism to impartially judge the comparative merit of the candidate partaking therein. If such an examination is saved, merit would be casualty generating a sense of frustration in the genuine student, with aversion to the concept of examination. The possibility of leaning towards unfair means may also be the ultimate fallout. Now kindly see the next sentence. Even if one undeserving candidate, a beneficiary of such illegal mechanization, and next two words are important, though undetected, is retained in the process, it would be denied of the same or more deserving candidate. At present, the examination stand denuded of its sanctity and not possible to be cleansed of all the participating beneficiary candidates with certainty. We are thus on an overall assessment of the material of record left unpersuaded to sustain the examination. So even one is undetected. There is a doubt the process was to. Then, my lord, this your lordship will kindly come to the next principle, my lord, that if period has been spent, because the argument is they work for 4 years, 5 years, 7 years, 8 years, so why should they be now and not removed? But in 2017, a number of different views were being taken and 3 judgments of your lordship, my lord, in the FCI matter, where, my lord, yes, the context was that the certificate with regards to those scheduled tribes and scheduled castes had been found to be not fulfilling the requirement of the order to extend reservation. The judgment is in this compilation. Your lordship will kindly come to judgment number 10, which, my lord, is 2017 8 SCC 670, and kindly come to, my lord, para 25 of that. I'm sorry, for para 24, which is, my lord, the printed page 698 of this judgment, and, my lord, this compilation 274. Kindly come to, my lord, Placidum C, 3 lines above that quoted portion. 3 lines above quoted portion. The High Court reversed the decision, and the appellant was dismissed from service. Before this court, the appellant inter alia sought protection since he had rendered nearly 27 years of service. So in this case, Lord, which was a batch of petition, 5 years, 10 years, 15 years, and 27 years. And this is an earlier judgment, my lord. This is 2004 decision, which is, my lord, reiterated and approved by another 3 judgment by Justice Chandrachud and lordship then was. And, my lord, each paragraph dealing with each judgment gives the duration. And, my lord, therefore, the court said that the concept of the appointment being void will be applied. And therefore, what duration you have spent is immaterial. Now, my lord, there was a doubt again. And then, my lord, it went to another bench on 4 years, where, my lord, your lordship will get the judgment by Justice Parthivala, my lord, 322. This is Satish Chandra Yadav. Entire law is discussed again. And I just wish to, my lord, your lordship, I wish to show the last paragraph, where, my lord, this argument of 4 years, etc., has been put in service. Kindly come to 106. My lord, the judgment repeats, my lord, up to the law laid down in FCI, analyzes FCI of 2017, and, my lord, on the facts of that case, kindly come to para 106. So far as the connected appeal arising of so and so, filed by so and so is concerned, the same also fails on the same very line of reasoning adopted by us. The only difference in the case of appellant is that he had put in 4 years of service before he came to be terminated. So time spent is immaterial. The concept of appointment having been obtained illegally and void appointment, therefore that will not be a factor to be kept in mind by the court that they have spent time. Now, therefore, if for the appointment has to go number 1. Number 2, no hearing is required to be given. Number 3, time duration is not to be seen. Kindly now come to this small compilation which I have handed over. 3 authorities were before the High Court. Now, this has. Now, in 136, your Lordship considering the judgment of the High Court, whether the High Court has wrongly applied any principle laid down, I just going to take 10 seconds of your Lordship, The first criteria is, are there any gross illegalities? If there are gross illegalities, then generally, the entire process must go. And that is by servant principle, which was in the case of
ফাইনাল জাজমেন্ট আসতে পারে,
which is on the revisions in the MBBS courses. The court now adopted a principle that even if there is a possibility of not identifying even one person who has illegally gotten admission, but he could not get detected, the process must go. I had the occasion to save that process. I was appearing for the government and CBI, and these were admissions to the counseling which was to take place for MBBS admission, and the effort was why everybody should suffer. So the court said even if you are not sure about one, the process must go. Then that, as I have already said, chapter that no individual hearing is necessary, and FCI we say no period should impact the court. Now the next submission which I am making is there any default or a defect in the learned High Court not following the Lordship dictate? The principle not followed. If principles are not followed, the general rule is no interference under 136. And now try to see what the High Court does. High Court asked the 3 authorities first. Can you assure me that this list is final? Kindly come to paragraph 242. Now I am only giving the responses which was specifically asked from these authorities. They got recorded in the High Court judgment. Please see the approach adopted by the High Court. In my humble submission, it is absolutely the approach which needs to have been adopted in compliance with the principles your Lordship have laid down. 242. If your Lordship may have my note, my Lord, I have given the relevant line. I can go to the judgment, but it would save time. The first authority who was asked is SCC. Are you sure about the number of the people who have illegally obtained it? In course of para 243, the relevant line, in course of hearing, SCC did not discount the fact that possibilities of further illegalities are there, then kindly come to 272. Before I read 273, kindly come to the next page, para 265. I'll come back to 273 later. Kindly come to 265. This was SCC. Now please see what is the stand of the state. Para 265. State government therefore has accepted there were widespread illegalities in the selection process and that the number of persons who received appointment illegally could not be determined with exactitude. So the SCC raised hands, state raised his hand, kindly come to the previous page 273. Last line on the page number 2, my lord. SCC at no stage of hearing claimed that it was able to check all the records and be definite as to the number of illegalities in recommendation made, but had limited itself to those figures as stated in the paragraphs above. In fact, reports in the form of evidence filed by SCC from time to time had always stated that they discovered the illegalities were brought to their notice by the litigants or by the orders of the court. And if it is left to them, they raise their hand in despair, we cannot find out. Now please see what the state says, I can't find out. No number exactitude I can give. And my lord, the finding is recorded in para 269. SCC board and the state government have consistently stonewalled any query with regard to selection process and have not come clean with regard to the manipulation, illegalities involved. Conduct of three authorities during the course of hearing can be classified as anything other than being cooperative. These findings are not, there is no quarrel with these findings. This actually happened. Therefore, the High Court said, first of all, I must find out from these three authorities who are directly involved. Everybody is running away. They can't even be sure what is the number. They say we have not even been able to correct our record, we have not been able to verify our record. We cannot tell you. Then, kindly see what the High Court does. The next, from 320 onwards.
Yes, Father.
Now, these are the principles, the observation made by the Honorable High Court with regard to three authorities, non-cooperative and admitting that we have no record, whatever record we have been able to see, we can't say with certainty how many people have illegally obtained it, nobody can say it. High Court now, my lord, with this admitted factual position, applying your lordship principles, my lord, which have been laid down, kindly come to para 320. These paras, my lord, I am relying upon. Your lordship have read many times, only three I will read it. I have given it in the written note, my lord, your lordship will kindly consider. First is 320. In the event it is impossible or highly improbable to shift the grain from the shaft. So please compare it with para 20 of Tanvi Sarwar. Even if one has illegally obtained, even if he remains undetected and that probability is there, cost the entire process. Kindly come to 326. The entire selection process is shrouded in such mystery and in such layers that it is difficult to fathom the quantum of illegality performed. And I'm beseeching your lordship's indulgence, please test these observations in the light of the jurisdiction under Article 136. Is there any such a defect committed by the court, by the High Court, which shakes the conscience of this court to interfere in the matter? Can you see 329? Number one, I had the occasion to appear in Assam case, where the OMR sheets, they disappeared, and in the house of the chairman, blank OMR sheets were found, so that whosoever comes with money, he is again blackened and posted. That is not, and the other appointments of course. Kindly see what 329, blank OMR sheets have been submitted, such candidates have been shown to record sufficiently high number. The exact nature of candidate fraudulently given the appointment cannot be identified, more so in view of the attitude of non-cooperation exhibited by SSC. There are other manipulation illegality in the selection process which have not come to light. And 330, since it is impossible to separate the grain, therefore we have no other option. Then 331, retaining appointees selected through such a dubious process could be contrary to public interest. 332, the selection process does not inspire confidence to hold that appointed person has been selected in a fair and transparent manner. Person submitting blank OMR sheet had secured appointment, amongst other illegality, and therefore those directions are quoted in the note. In this note on the subsequent pages, and in para 9 onwards, the judgment compilation which are handed over with those 4 paragraphs to be kept in consideration by your lordship. Therefore, my lord, it is a case where the conclusion drawn by the Honorable High Court, in my humble and respectful submission, my lord, do not fall foul of any of the principles which have been laid down by the Honorable Court, which ought to have been applied, and either been not applied or wrongly applied. Therefore, my lord, your lordship and the one that is it will not, my lord, consider this case, but for only quashing the entire selection process and the recruitment and selection to be made once again, so that no merit is compromised, and this colossal fraud which has taken place, is suitably dealt with by your lordship, by confirming the judgment of the Honorable High Court. That's my respectful submission, and duty applies to the grades.
Your lordship, so I'm appearing for the 10th August.
What do you have to say?
If in this regard, the first query that was put to us regarding the authenticity of the data that we had recovered from Pankaj Vans. Regarding that, on the last occasion, Mr. S.V. Raju had handed over a note, a 3-page note. If required, I have placed copies again, I can scale it.
Can we have copies, please? Can we have some copies?
My lords, may we also have copies of the note? Copy.
Yes.
Can we have some? Can we have 4 copies?
Also, it comes to the first page. Possible note, originally, the entire scanning process was originally done by NISA. NISA had given it to another authority, which was Data Scantek. Data Scantek was the authorized authority. Thereafter, those data was provided to the SSC. SSC had deleted those data as per their rules. The examination period was 2016, evaluation was done in 17. This pertains to 4 stages of examination: Group C, Group D, 11, 12, 9 and 9, 10. Now, let's see, when we asked NISA, please provide us the data, NISA said we do not have a copy of the data. Thereafter, we went to Data Scantek. From Data Scantek, we had recovered data from the deleted portions of the files. So we had this one set of data which we recovered from Data Scantek. The files were originally deleted, but we managed to recover those data. Another set we recovered from the 3 hard disks that we recovered from Pankaj Johnson. So we had 2 data to compare with. Now, let's see, whenever this scanning was done, it resulted in 2 versions of the copies. If Lordship comes to the first page, there is an image copy, there is an exact scanned copy, and another is a response code. If Lordship also sees in the interim order also a response code sample has been put in at page 238. If Lordship sees both side by side, the picture may be a bit clearer. Page 238 of the interim order refers to a report of the CBI which was submitted before the Honorable High Court. In that report, we have also given details of the investigation, how the data was recovered and everything else.
Page 238.
238 of the interim order. In the bottom, Lordship will see there is a table put in.
Yes.
This table is the data which is equivalent to the response code. So we have to match 2 forms of data. One was the image copy, one was the response code that we are recovering. Now let's see, we check with the response code data with that of the data which we got from the panel evaluation. So we'll come to the reasons portion, which is on the next page, and I will go through
I just put that slide.
Yes.
There was a scanning done.
Yes.
Now, sometimes the scanners themselves mark the data.
Yes.
Depending upon the circles which have been done.
Yes.
In this case, that is not done.
Yes.
It is manually checked.
Yes. No, in computer generated checks. So that's why we got
computer generated AI check.
AI check.
So it was automatically feeding the format sheet. You get the answer.
Yes.
So you get the marks.
Yes, sir.
So it was not done manually.
Not done manually.
But there is discrepancy between the OMR data found on the hard disk or retrieved from the hard disk from data stack.
Yes.
And the 3 hard disks which were retrieved or which was seized from Pankaj Johnson.
Those matches also.
They match.
Yes. That's why I come to the, if it also comes to the second page of my note, I will read that first, it will be easier.
So what do you mean by this? If we response code, what do you mean by response?
Response code is a table format which I was trying to start page 238. That is the response code data. And another is the exact image copy once we scan it.
Okay, fine. Okay, fine.
So we get these 2 at the time of scanning 2 copies, image copy and response copy. Now this response code is used to validate the answers provided by the candidate.
Correct.
And calculate the marks based on the predefined answer keys corresponding to each question paper. This is done automatically. And authenticity. For authenticity check, then there is a stage where the scanned OMR can also be checked so as to ensure whether the automatic checks that was done through the machines matches with that of the scanned data or not. Then verification of the hard disk, and then I will come to the reasoning also. Why we say that the data which we got from Pankaj Johnson is actually genuine and authentic. The first is, as directed by the Honorable Single Bench of the High Court at Calcutta.
Yes.
I'm at the second page of my note. The reasons, point number 1.
Yes.
As directed by the Honorable Single Bench of the High Court at Calcutta, the scanned OMR images retrieved from the seized hard disk belonging to Pankaj Johnson were handed over to the West Bengal Central School Service Commission. The WBCSCC subsequently evaluated these scanned OMR images using the answer keys available with them. They had the answer keys. Upon evaluation, the marks calculated by WBCSCC matched the marks stored in the seized hard disk of Pankaj Johnson. This is the first point, that it matches. Second, during investigation, one email dated 15/7/2017 was seized by CBI, which was sent by Pankaj Johnson to accused BAISHAKHI Bhattacharya, then chairman of WBCSSC, and by this email, the actual marks scored by the candidates in the written examination for the post of Group C was shared. The same data was also found in the seized hard disk of Pankaj Johnson. Then, as directed by the Honorable Division Bench of the High Court at Calcutta, an inspection of the scanned OMR images was arranged for candidates or parties who applied for such inspection in accordance with the court's order. Following the inspection, no candidate disputed the authenticity of the OMR image shown to them. asserting that it was not their own. These observation was also noted in the judgment, interim judgment at paragraph 289. There was the hash value. This is very important. The hash values of the data seized from Mrs. Data Scientific Solutions responsible for scanning the OMR data answer sheets of WBCSSC candidates on behalf of Mrs. Naisa matched with the corresponding data found in the sheet statistics of Pankaj Bansal. So we have two data, the hash values match. Similarly, the response code generated during the scanning of the original OMR answer sheets by Mrs. Data Scientific Solutions acting on behalf of NISA were found to match the corresponding data stored in the hard disk sheets from Pankaj Bansal. This relates to the modification date. Whenever a file is created, it will create a modification date. So the modification date of both of these data, the one from the Pankaj Bansal and Data Scientific matches. Furthermore, the dates of modification for the scanned OMR images found in the hard disk sheets from Mrs. Data Scientific Solution and Pankaj Bansal were identical. These modification dates also correspond to the period when the written recruitment examinations were conducted by WBC SSC, thereby affirming the authenticity of the data. The differing dates of creation reflect the transfer of data onto a new medium, while the modification dates represent the actual creation dates of the original data. We also had the 65B certificate. We had produced those certificates before the Honorable High Court. Honorable High Court at this point has ruled in favor of the CBI.
Bansal data retrieved by you. The three artists.
Just a second. So in September
2022, 16 September.
Yes, 16 September 2022, that's reflected at page 242.
And when is the scanning done? Date?
The scanning was done way back when the examination was conducted in evaluation.
Some picture for the first time in December 2023. In fact, January 24 in the charge sheet. And
Scanning, initial scanning.
that is a big question. That's a big question.
Initial scanning is in the process of evaluation only.
Paragraph 6, what you said.
Yes, Lord.
Please read paragraph 6 again.
Similarly, the response codes generated during the scanning of original OMR answer sheets by Data Scientific Solutions acting on behalf of NISA were found to match the corresponding data.
Where did you get this information? From what we understand, except from what was retracted from Pankaj Bansal, there is no other information available. The
Data
Service Commission doesn't have any hard copy.
We had the data of the response codes data. So we compared first of
mirror images are not available.
Mirror images are not available.
So this response code is still available.
Yes. The response code data, one set we got from the data scan tech, one set we got from the hard disk of Pankaj Bansal. We compared both, and the relevant modification time matches on the date on which the original examination had taken place.
Mark sheets of Pankaj Bansal data, you will have to show there were gaps.
Yes.
There were gaps and manipulation was done.
No, Pankaj Bansal data is the original data.
Original, that's the original data.
Yes, that's the original data.
According to you,
No tampering.
no, that has not been tampered.
No tampering on that data. That is the original.
Hash values are as per the date on which the
Original evaluation had taken place.
Yes. But the hash value should have undergone a change because a simple reason. Last year was the one who did that scanning.
Yes.
Sasya is the one who did that.
NISA actually gave us.
They gave it to them.
Yes.
But Pankaj once, therefore, but the hash values, whenever there's second copying also will undergo change. The Pankaj Bansal is not the first copy. You also accept it's not the first copy.
No, I'm saying Pankaj Bansal is the second copy copied from the data that was available with NISA.
But the when you copy,
It's the third copy, my lord. It's the third copy. It's NISA, Data Scantech, and then Pankaj Bansal.
No, NASA did not do it. I thought they do it.
NISA did it.
I beg your pardon, my lord. It's SSC, Data Scantech, and then Pankaj Bansal, and on the my lord, regardless, the last that's I beg your pardon, my lord. That's my lord. And I lord, just on the hash value, since the CDI was the metadata of the hash value.
This at my turn, but this goes to the root of the matter. This is crucial.
This is not evidence in the eye of law. They have to satisfy us.
This
is crucial, my lord.
We'll not hear anybody like this. They have heard your claim. We have already heard you. Whether it's evidence in the eyes of law, whether the Evidence Act applies, what is the effect of 65B, we've all heard you. Don't say that. Yes, please.
Lordship, the first scanning that was actually done was done by the Data Scantech. That was the first authority. From Data Scantech, it has gone to NISA and then to SSC. NISA's one person was this Pankaj Bansal. Pankaj Bansal had copied the data, which we had recovered during a search proceeding. We don't have the.
You have yourself about Pankaj Bansal also.
Yes.
Lamented
that the hash value matches.
So, but they also said that they put gaps. Because if you look at the Pankaj Bansal, your argument before about Pankaj Bansal, which has been quoted, that's why Mr. Maninder said, you have said over there that it is not possible to that, not possible to rely even on that data. That's as per the division later.
Please come to that finding.
It's not possible to rely upon even Pankaj Bansal's data.
But from our investigation, I can only say this thing.
That you feel that
that is the original data that is undone. That is what our investigation has revealed.
And that data matches with the
Data Scantech data.
That's
yes. And all of this matches with the same modification type.
But the marks which are appointments are not made in terms of that data?
No, not. That's why we say that there is a final tampering between the original data, which is the Pankaj Bansal data, and the marks and data which was subsequently put in and upon which all the appointments are done.
So the data which is maintained by the SSC is tampered data.
Tampered data.
The original data, which is untampered data, is the data with Pankaj Bansal.
Please. I'm appearing for the people who were excluded. They were they would have been in the merit list, but for the tampering, your lordships. So now, as per paragraph 335 of the impugned judgment, your lordships, various conclusions have been arrived at, and what was the irregularity and illegality, those have been succinctly set in over here. If your lordships will just mark para 335, subpara 8, small Roman 8, 9, 10, and 11, your lordships, 11 and 12.
335.
335, subpara 8 to 12.
Yes.
So there are 4 kinds of major irregularities. The first, your lordships, is appointments higher than the declared vacancies have been given in respect of all 4 categories. Number 9, appointments have been given to persons who were not even in the panel. Number 10, appointments have been given to the persons who submitted blank OMR sheets. Number 11, appointments have been given to persons after expiry of panel. And number 12, persons placed lower in the rank have been given appointment in preference to persons placed higher in the rank. So your lordships will see that these 4 irregularities, in fact, at this time and distance, seem to be established, because whatever SSC may say, it has come on record by way of investigation, by way of subsequent confirmation by metadata, that the SSC data on basis merit list on basis of which appointments were given had these 4 categories included in that which were illegally included. Then your lordships may kindly see, which is very important, is number 13, that the merit list containing the marks obtained by the respective candidates has never been published. For that purpose, your lordships, I had also indicated to your lordships the earlier order of the Honorable High Court when the entire scam had broken loose in the Honorable High Court. The Honorable High Court had ordered your lordships by order dated 12/5/2022, which your lordships will find at page 396 of volume 3 of the compilation. Page 396, volume 3. Lordships need not refer to it right now. Suffice it to say that a direction was given that the merit list should be published. However, that was never complied with. Then, your lordships, what happened was that with regard to the rules, because when the High Court went through the rules which were to be followed, it found that the rules had not been followed. And for that purpose, your lordships, if I may just refer to the rules your lordships will find at page 93 of the compilation of volume 1. A lot will turn on the rules, your lordships. Lordships may see that I'm referring to class 11 and 12 rules and their paramateria by and large of all the 4 categories. If your lordships will come to rule number 12. Now the rule number 12, your lordships will see, provides the procedure for the purpose of selection. And going by the Nazir Ahmad principle, your lordships, 1945 Privy Council, which has been consistently followed, Rule 12 had to be followed for the purpose of declaration of the merit list and the procedure and the method of selection. Now, if your lordships will see, if I may just draw your lordship's attention to Rule 12, that the Central Commission shall arrange for proper custody of all online applications which may be received by it against the vacancies. Central Commission, after receiving application, shall prepare a list of eligible candidates for purpose of preparation of a computer-generated database of all the candidates. This is the preliminary stage, whether he is citizen of India, age bar, all those things. The admit cards for written examination shall be issued by Central Commission by any mode as may be determined by the Commission. Commission shall arrange written exam. Commission shall determine method of written exam, contents of papers, etc. Commission shall decide the procedure and the manner of conducting selection tests. Now the important part comes now, your lordships, which is sub-rule 6. After evaluation of OMR sheet or answer sheet of written examination, the Central Commission shall prepare and publish in their website with all details of the candidates to be called for personality test, category-wise on the basis of merit, marks of written test, academic and professional qualification, as mentioned in part A of Schedule 2, in ratio of 1:1.4 of final vacancies. Sub-rule 7. Central Commission shall prepare and publish in their website a merit list of candidates prepared category-wise on basis of marks obtained in, again, 3 aspects, your lordships. Then 8 is with regard to the proportion of 1:1:4. And then the proviso is important, your lordships, which is 1:1:4. And then subclause 10. Central Commission shall publish such panel and waiting list of candidates in the website of the Commission as well as offices of concerned regional commissions. Copy of the same will be submitted to School Education Department, etc. So the first merit list which had to come out, your lordships, was with regard to the eligible people for the written exam. After crossing the written exam, again another merit list was supposed to be published with regard to persons eligible for the interview test. After that, a merit list of 1.4 of the number of vacancies, 1.4 times of vacancies, panel had to be made, your lordships. And then your lordships will come to schedule 2, which your lordships will find at page 99. And this is how the candidates were able to identify the illegalities committed. Your lordships will see that there is a categorical breakup given of the exams and the marks to be taken and the weightage to be given, which could not be tampered with, because the school exam, class 12 exam marks could not be tampered with. That was a fact, a hard fact, which SSC had no control over. So your lordships will see selection to the post of teachers of class 11 and 12 in schools shall be made on the basis of written examination, evaluation of qualifications of the candidates, and personality test to be determined by the commission in the following manner. So written examination is the OMR. The weightage was 55 marks. Academic qualification, including professional qualifications, weightage is 35 marks. And personality test is 10 marks. Now your lordships may turn to part B. And how, your lordships, the weightage of clause B, which is the academic qualification, would not be a variable number. It would be a constant number, your lordships. Lordships will come to part B. And if your lordships will see the first row itself, the examination is school final or madhyamik or its equivalent, which is class 10. Full marks out of 35, your lordships, 6 will be given if you have got full marks in your class 10 examination. If you have got 60% and above, you will be getting 6 marks. There is no discretion in this. Below 60 up to 45, you will be given 5 marks, and below 45, you will be given 4 marks. And then there is relaxation in educational for reserved candidates. Similarly, class 12 marks, the weightage is very clearly given. So your lordships, now what has to be done in this situation where we find ourselves, your lordships, where these 4 irregularities have been committed, which have been more than established. And considering the fact that this is not a criminal case, because a criminal case is pending with the CBI, that as far as those consequences are concerned, those will come. This is a matter now, how are we to balance all the equities, including what do we do with the 2016 selection, where these irregularities have come to light only 2 years after the selection has taken place. It was consequent to 1 or 2 writ petitions which were filed, in which this entire thing came out, where RTIs were filed, where the whole fraud had come to light. Now, since the fraud was discovered only 2 years hence, your lordships, then the Lazarus doctrine will again apply, and what has to be done going forward has to be seen, your lordships. As far as making a merit list is concerned, now we have to segregate tainted.
See, the difficulty is this.
Yes.
Don't have the original mark OMR sheets.
But CBI, yes.
CBI says that the data with puncture person matches with the data which they will be able to retrieve from and deleted data from them. But still we can't authenticate and vouch for.
Yes, Your Lordship.
We can't authenticate and vouch for that this is the original one, because in the absence of the original mark sheets, then this that suspicion is now today, even to the extent whether these are the original mark sheets of the candidates.
Very well.
Whether these are original MOM data mark sheets of the candidates.
Very well.
Because if so much is happening, there's so much bungling which has been done at such a large scale, vast scale, it's impossible to authenticate that.
And I'll just respond to that, Your Lordships. Now, let us see what are the alternatives that we are faced with. The first alternative is what the High Court has done, to cancel the entire selection. Now, Your Lordships, 2016 selections, there were candidates.
And in this case, not only the problem is that,
yes,
the problem is not to take the data as it is available in CSE, import it.
Yes, sir.
Match it with the
yes,
personal data. that would have been, if that was so simple, it would have been done. But today, date and age, and we have doubt on even Pankaj Bansal's data because the original OMR sheets are not there. Then what to do?
Yes, Your Lordship. So I'll answer that because that has been deliberately done. The destruction is deliberate. Therefore, to the secondary evidence. So I'll just come to that aspect. But first, let us examine, Your Lordships, the option of cancelling the examination. What are the consequences of cancelling the examination? And balancing all persons.
You are not even selected.
Your Lordships, I'm not.
I can understand somebody. No, one minute, please. Others who have got it wrongly can be knocked out.
They can be knocked out, but then Your Lordships
Maximum case of repetition is knock them off. But don't pull down those who are not involved. But what you are asking for is step beyond that. And if delay in latches applies to the other side, in your case, delay in latches you completely out. What you are saying is, after you knock them off, whatever balance is left, please let us fall into
meritorious people.
How can no? But that
But when be the meritorious people, I'm just
and in
proposing.
a case where the merit list is already exhausted, the time for merit list is already final list is already exhausted.
Bear with me because Your Lordships, as Your Lordships have said, this is not a simple situation. There are too many complexities involved in this. So how do we put all those complexities together and come to some solution which will take the best, all the best options can be examined, Your Lordships. So this is what I'm putting to Your Lordships, that as far as knocking off the entire selection is concerned, there are two big consequences that arise out of it, which are not permissible under Article 14. First, Your Lordships, is that as far as the people who were meritorious have a substantive legitimate expectation to be considered, because here we are not at a point of time where the case law with regard to you are on panel, you don't have a right to be appointed. But I have a right to be considered in accordance with my merit. So that right being a substantive right and substantive legitimate expectation, I can't be thrown out because SSC conducted it in a particular manner, did some ghapla here and there, Your Lordships. My valuable right, because my right to public employment is a very, very valuable right, Your Lordships, especially in the current economic circumstances. So given that fact, Your Lordships, if everybody who falls into the merit list must be considered. Secondly, Your Lordships, if this whole selection goes, then what about the candidates who had appeared in the selection? Now, Your Lordships, we'll all be faced with an age bar. How do we then come with a systematic solution to that? If we are constrained by the age bar, now Your Lordships will see that there will be new candidates who will come into the newly declared vacancies. So what does a fresh selection mean? A fresh selection means that you continue the process from stage 2, which is Rule 12(6) onwards, you continue the process, because the people who had appeared in that selection must be the only people who should be considered for fresh selections, except the ones who are tainted people. The tainted people have to go out, Your Lordships, because the tainted people.
Understood, that argument is far-fetched, but understood.
Your Lordships, it's not so far.
That's saying that only those people who had earlier appeared could be permitted to appear.
Lordships, then what? 2016, this is after 10 years. We are not talking of a situation.
Correct, well, that's fine, but that's fine.
Ago, Your Lordships. Now, if we go for a.
That's always so when the merit list is exhausted.
Because, Your Lordships, the OMR mark sheets, as far as the OMR sheets are concerned, now CBI, Your Lordships, has very categorically said that it has done all the data mining, it has done the metadata mining as well, and has come to the conclusion that these two, this and Pankaj Bansal's OMR sheets match. So whatever OMR sheets are contained in that, suppose there are say 100 OMR sheets which are not contained in that. So forget those OMR sheets, there has to be some collateral damage. Your Lordships, we are willing to take that collateral damage. But all the OMR sheets which are there on the Pankaj Bansal drive should be, a merit list should be made out with that, and the process should start from there. That is my humble submission for your lordships. And I have one more thing to say, your lordships, because this is not a problem just arising in this matter, your lordships. Now, this is with regard to recruitments, which are running into thousands and lakhs of people, your lordships. This is as an officer of the court, I'm just submitting to your lordships, because there are several.
Just one thing, for the CPA, your conclusion that you listen us. Probably total, what is the total number of recruitment paid to the four posts?
Total number is
25. So that, have a chart.
Mr. Jaideep Gupta, how many were total number of appointments in each of the posts?
around 25,000. Total appointments and total appointments.
I will just.
65 minutes, you know, I can post it. And you have to break up of all the posts?
Your lordships, this we have culled out from all the various.
No, you don't do that. Let the government and the CBA tell us.
Yes, your lordships.
You don't do that.
From
No, we lead to further discussion. So in all about 25,000 appointments have been.
Yes, sir.
How many did you advertise as, how many according to you were illegally made?
There are two categories in it, Milord. Our own record shows that there was what we are calling, Milord, rank jumping and out of pattern, where we have not given a recommendation at all. Milord, those do not appear from our own records when we revisited the record. There is a second category, Milord, where there is an OMR mismatch. There, Milord, we don't have the record. We are proceeding on the basis of CBI's finding. So we have, Milord, given a makeup.
It's a never-ending.
The lordships
will not show.
Volume 6.
They say 952.
I'm sorry.
Another part they say 152.
No, all this has been reconciled. There is no difficulties of figures just now. So these two categories, Milord, are there. Whether, Milord, there are any other categories, Milord, the lordship will consider, Milord, based on article. Lordship, but Milord, we are able to segregate each and every category.
Two categories only. Do yourselves to say if there is any other category, I don't know, you may do it.
No, I know. I cannot make that segregation. If you say, for instance, Milord, if your lordship says that the last counseling is out of time, then how many people will be affected by that?
You can't know.
We can give that figure.
That figure you can give.
Similarly, Milord, we have now.
No, there are two types of mismatch. One is where the marks in the Pankaj pencil do not match with the marks available with you.
In my son.
In your son.
Yes.
And you can't even say, to be very frank, whether your server marks are right or the Pankaj pencil mark.
But I cannot.
Because you cannot say because you don't know.
Yes,
yes. We don't know.
But please.
No, but
you don't know. But if you accept, CBI report says on metadata that Pankaj Bansal appears to be the original. But obviously the defense being taken, which will be taken by all your officers, would be my marks are genuine and Pankaj Bansal's marks are not genuine.
That's right.
Say, no, please. Bishop Atwalia, I'll take away the evidence also. We behave to do like this. It's not possible.
Now you can give us his 10 minutes.
Bro, we have heard you for more than 1 hour. 1 hour. So, where we, why the hell we are putting questions, we want answers. When, please. We have to close it. We have got 1 hour more, we have to close it back.
If there's an affidavit.
I would take only 5 to 7 minutes, because I have really not made it.
1 minute, please, Mr. Gupta first. No?
Give me 5 minutes before.
Okay.
5 minutes for me.
Okay, fine.
I am standing by the CBI investigation.
4 minutes, my lord.
No, accepting it and proceeding on that.
You're signing that.
And they have segregated your lordship.
Okay, according to you, as per the charge sheets filed by you, how many have been wrongly appointed?
First, will kindly come to our written submissions that is filed in the Supreme Court. The data and figures are there. There are.
See.
Yes, sir.
But we have given the exact figures.
That your lordships will find that volume 6, page 14 to 17.
Volume?
6, page 14 to 17 of the.
No, that's in the Supreme Court or
That's in the Supreme Court. Supreme Court. Written submissions in the Supreme Court.
My lord, to make things simpler, have a printout which roughly.
No, let the CBI give.
It's already here on the screen.
We can't have five.
That we can speak with CBI and will not authenticate it, will not no difficult.
Only authority is there.
Not staff up here.
Not everybody.
Not everyone.
5,189.
5,000?
189 out of 25,840.
5,189.
But that is only in case of AMR.
It's a
But 240, the SSC admits, my lord, 240 paragraph, the SSC admits it is more than 10,000 and they say so far.
Milord, this
In their own affidavit, they say so far.
Milord, Mr. Rauff is wrong.
Where does this figure come from?
But I get the lordship, Milord. My judgment is wrong because
It's your affidavit.
statement taken from an affidavit of 2022.
So then this
Where it says that this is what we have so far.
more than 10,000.
Now, Milord, what does number after Milord, CBI investigation takes
Page number
place
14.
and after the CBI investigation? Yes.
The fact of the matter is,
Yes.
as per your own internal investigation, first you found about the figure will be close to 10,000.
And
But
কথা বলছো
as per your own internal investigation,
Yeah.
first you found the figure will be close to 10,000.
10,000.
That's what you said in the affidavit.
No, not 10,000.
That's
I don't know where my learned friend is getting 10,000.
your affidavit below the
we
High
can
Court.
calculate and show 10,000.
No. Your lordships will see lordships' own order.
If
Not more than 10% people are tainted, your lordships. Lordships' own order dated 7/5/24.
okay, we have understood. That's what, as per, did you file any affidavit giving some figure of 10,000?
No.
No, you never filed anything.
No, Milord, we have given a figure now of rank jumping plus OMR. I think it's coming to that 5,000 figure which Mr. Henry was talking about. I'm just taking it out.
This is the chart prepared not by us on the basis of the SSC's affidavit.
Milord, that is not our document. My learned friend is filed in Supreme.
It's your document filed in Supreme Court.
Lordships, the problem is SSC's,
Nobody will speak out.
very well, because they
Nobody
changed
will-
hands several times.
Yes, that's true.
5 minutes. Page number in the volume is given. 5 minutes by the clock. I miss no money.
Please wait for your turn. Nobody will speak out. When we call upon you, you'll speak. Just give it.
Why is it that I'm not finding the? Yes, in the calculation.
5485. But as per Mr. There it is 10,750.
That's given by me, putting from the affidavit of the SSC filed with the division.
Milord, this is just creating confusion. It happens fast.
No confusion, SSC itself is confused.
No. SSC is not confused. At least for the time being, it is not.
And we put in at the bottom.
Please give it
The
with
references.
So these figures are there in the judgment itself.
Yes. And the reference from the CBI we've given at the bottom in the foot.
Sorry, 10,000.
10,000 mandates.
Yes, that will be given from different affidavits by SSC.
Milord, in this court, we have made an application which is an IA, in which not only is the figure given, Milord, but all the names are also given.
This application will not just respect.
So how did you compute this figure?
But this, we've given it at the bottom.
Yes.
Why not be looking at 10,000?
Right at the bottom, the PDF page number Volume 6, page.
Little submission of SCC before the Supreme report. OMR issue means that the marks with the OMR are different from the marks available with the
SSC.
SSC. Rank jumping is where somebody has been upgraded despite the marks.
And my lord, CBI gave figures which included those who are not empaneled. There is a little difference there because my lord, CBI includes those who are not empaneled, but there may be a mismatch.
Okay, fine.
But my lord, we are concerned with only those who came into the panel, and there is a mismatch.
I have given a chart.
My lord, these figures can be reconciled between us also.
The total illegal appointments are 10,750, which is 41.59% total appointment. And given the reference of SSC affidavit, it was right.
Page number page number
Everything. My lord, that is not from SSC's affidavit. Part of my learned friend has been, my lord, saying these things from the beginning without reference to the record.
Page number is given. I have given the references to your affidavit also.
Anybody else now one by one?
Well, may I take 5 minutes?
Please start from that corner. Basically, came in the last, we get the last one.
Your Lordships, one sentence I wanted to say. I've just handed over some suggestions, Your Lordships, to augment Tej Prakash. Because after Tej Prakash, Your Lordships, this is a very widespread problem. I'm just handing it over to Your Lordships.
I'm sorry. This is 1 page. This is not your.
Sorry, let me just take my back.
Well, I have some points on rejoinder. Okay, at whatever time, either it
You finish first, and then 5 minutes we go by clock. 5 minutes. Stop you. Anybody at 5 minutes?
5 minutes. Number 1, my lord, the finding of the High Court that SSC has not cooperated is incorrect. We have filed, my lord, 4 affidavits.
Leave that part.
All right. We have filed 4 affidavits, my lord. The only effort was to segregate. Only. Well, I'll give that in a note. Number 2, my lord, the question of, my lord, there being an affidavit saying that we are not sure whether this is the last figure. These are, my lord, affidavits which are prior to the matter going before the division bench and prior to the point where the CBI has given a complete analysis of what they have found. So, my lord, that position does not hold anymore. With the CBI record, the position is complete. Number 3, my learned friends had twice referred to, my lord, Tanvi Sarwal's case. That was an extreme case, my lord, of, my lord, people having, my lord, SIM cards sewn into their desks. That has been, my lord, distinguished by your lordships in the last judgment of Vanchika. By name, it has been distinguished, saying that this is not the approach to be followed in Vanchika. So my learned friends, my lord, have continued to refer to Tanvi without, my lord, saying that this has subsequently been referred to and distinguished. Then, my lord, the next point is that it is alleged that there are appointments that the figures between the board and the committee. My lord, we are the commission. Mr. Hegde's client is the board. He appoints, he issues the appointment letters. We issue the recommendation, we hold the examination. Now, my lord, there is some discrepancy between his numbers and my numbers. That was what was said. So, therefore, the inference which was sought to be drawn by the High Court was that there were more appointments than recommendations. Actually, my lord, we have gone back through that record completely. It is totally reconcilable because the two parties have acted on a slightly different basis. Now, my lord, your lordship knows that when a recommendation is issued and an appointment letter is issued on that basis, the next step is that the person must report and join. If the person doesn't report and join in that post, then there will be another recommendation and another appointment letter. Now, in the first instance, the board took all the appointment letters, including those which did not fructify in actual appointment, joining. Whereas we only took, my lord, those which ultimately fructified, my lord, in occupying, my lord, the position. Now, my lord, if we go through that record and we have done this exercise, if we keep aside those who did not take their appointment, then, my lord, it is completely reconciled.
So the time is over.
So, Lord, I am for those.
May I just say one more thing, my lord? A lot is made, my lord, out of one or two things, but, my lord, the overlap between it is not followed.
Yes, Mr.
Lord, I appear for candidates who are mismatched candidates. Now, I have a basic submission to make, that is, everything is hinged on Pankaj's hard disk. Now, up to January of 2024, no other data saw the light of day. CBI realizes that only Pankaj hard disk is there, and then there is data with the board. We say the board's data is authentic. CBI must have realized they need some corroboration. For the first time in the charge sheet, which is filed in January 2024, the CBI comes out with a plea. I won't use the word story, but with a plea that there is data recovered from the hard disk of Scantech. Now, if we see the affidavit filed by CBI before the High Court, which is at page 238, they say their investigation has revealed that NASA got the job to do this. What did NASA get? NASA was to compile the data. NASA gave it to Scantech. Scantech comes to the office of the board, does the scanning there, hands it over to NASA and goes away. The question of Scantech having original record in its office cannot and does not arise. And in the charge sheet, that record is supposed to have come from a pen drive. The charge
should have been on the other side.
No, my lord, no. I am very much here. Now that record is supposed to have come from a pen drive. Today in the affidavit file, it is on a hard drive. Now, all this is seriously suspect. The whole date, there is no authenticity. And therefore, my lord, we have been saying from day one, number one, that this action could not be taken until the trial is over. An investigation report submitted, there are two direct judgments of your lordship saying that
5 minutes only.
And
1.5 pages.
Second, there is no
others who are before you have this.
I will give a 3-page written submission.
No.
I was sitting at the back.
I have 30 seconds left. I will give a 3-page written submission fructifying this, Lord. And the data is highly, in fact, Lord, the board's record is genuine. This Pankaj Mittal's data is highly suspect. CBI is now desperately trying to get it.
Not Mittal. Mittal is our brother.
Pankaj Bansal. So, sorry. No. So Lord Pankaj Bansal, I will give a 3-page note and my
shows our love for lordship.
So my lord, I again reiterate, and we have been saying this from day one, unless and until the data is in a trial takes place, it is highly not proper.
Okay. That's it.
I have for untainted just 1 minute if you lordship will provide. Plus one, I'm here.
We are
1 minute plus for untainted 1.
I'm also untainted.
Plus just 1 minute if you lordship.
1 minute. Other anybody else arguing for 10 token?
Untainted, my lords.
Long time.
Untainted, innocent,
Okay.
empty, my lords.
5 minutes more. 5 minutes for the tainted one. Beyond what has argued earlier.
Lord, I am appearing for Group D, which is manual labor. Let's make a distinction, my lord, between the categories of people before you. We all have different grievances. So whenever they finish, give me 5 minutes.
Sir, please argue now. You're got tainted.
Yes. My lord, my basic proposition is when any action is being taken, justice demands that fault must be attributed where it is due. What is the fault attributed to me? I am a manual worker. I have applied under the rules of 2016. I have complied with the rules. Unless and until, my lord, I am told by way of a show cause notice issued to me that here is where you have committed a fault. The rules of natural justice have to be complied with as far as I am concerned. So, my lord, my suggestion is each and every one of us. And by the way, I don't fall in outside panel and I don't fall among waitlisted candidates. I have gone by due process of law, and therefore I am protected by Article 311 of the Constitution of India. My lord, I have been in employment since 2019. And my lord, there is case law to indicate, which I'll find in a written submission. Even if you don't invoke 311, you still have to comply with the rules of natural justice. So therefore, give me a show cause notice, and I will prove to you that I have committed no wrong. Secondly, the admission of the state cannot be binding on me. But the High Court has proceeded on the assumption that the state admits its own wrong. How is the admission binding on me? I'm given an opportunity to oppose that admission. Therefore, thirdly, submissions have already been made on 65B. The simple submission is 65B has to be given by data Scantech. The source who scanned it, they have not given a 65B certificate. Had they given it, matter might have been different. And last but not the least, my lord, so therefore, my lord, the crux of the matter is, do not do injustice to manual labor. In our case, my lord, there's no question of my trying to misrepresent myself. I've followed the rules. The rules which my lord and friend Viva read out don't apply to me. One last thing. One last thing. High Court says on a balance of probabilities, reading section 3 with section 58 of the Evidence Act, they overlook section 59. It says no balance of probabilities for electronic evidence. Read section 59. It says for since you must comply with 65B. That's all I have to say.
I want to.
Untainted candidate.
Untainted candidate. Untainted.
May I?
I want to make a brief submission that for the first time in the entire judicial process, that in this matter, after the earlier judgment of the Supreme Court, a dispassionate hearing is being given. That what started off in regard to a duty by a politically inclined judge who ordered a roving inquiry, that has now resulted in what has happened. Without
Not a core of the matter, we have facts now.
My lords are conscious of it, and therefore my lords are now looking at it in a serious manner.
Okay, please argue something.
I want to say this, even the division bench unfortunately seems to have been carried away by the media without giving a due opportunity to all the affected.
Okay.
On the tainted part, may I?
Okay, 1 minute. We start from here. Come down there.
30 minutes might have been several irregularities, but in regard to teachers, hardly 8 to 10%.
We know that argument.
For fortunately untainted people, my lord, I am not in OMR manipulation or rank jumping. I was part of the 8th phase counselling, my lord. The lordships are interpreting the rigor of Rule 15, my lord, that the panel expires after 1 year. If your lordship were to take that into account, from leaving the first 2 phases, all phases are impacted. Now, if I am not tainted,
first 2 phases is how many were appointed? The first 2 phases, how many were appointed?
Counseling itself is after expiry of the. After second phase of counseling. After second phase, all are after
not all after second phase, all are
beyond 1 year.
Counseling is after expiry of pen. But apart from that, another 2 types of illegalities are there.
Lord, can I have my 2 minutes?
Yes.
Exams are going on.
Lord, I have given those dates.
Where do we get the dates of the counseling?
I have it here. Your lordship would see at the top of the second page, Lord, the final publication was on 12th March 2018. The panel expired on 12th March 2019. Now, if your lordship would see the second page, the 3rd, 4th, 5th, 6th, 7th, and 8th, all beyond 12th March 2019. So, if your lordships are going to set this aside, everything will have to, including 9th, 10th, 11th, 12th. Now, 8th happened, Lord, because the High Court, if your lordship would see the second paragraph, directed that 8th phase counseling should take place. I have referred to that order, my lord. So, your lordship would have to then interpret this, keeping in mind that if they are not tainted, what is the rigor of 15 has to be.
Okay, yes.
No, I can only add 2 things to this.
one thing, everything goes, which my learned friend has said. But so far as the ninth phase is concerned, there was a direction of the High Court to hold the ninth phase counselling.
He's already out there.
This is legal and proper because, and there's no challenge to ninth phase. So if ninth phase there is no challenge, it's accepted. Then everything before ninth phase has to be accepted. Now the only ground that is taken by the board is that phase number 3 to 7, because there was an intervening stay of the High Court going on, so period of 8 months had lapsed. So we are covering this 3rd to 8, but they never 7. But they never went to the High Court to get an extension of time. So my lords, if it goes, then it goes from 3 to 12. But if they stay, then at least 8, because it comes before the order of the High Court of the ninth phase, has to
I'm representing Group C and
I can file my written submissions. There's a small 2-pager note with the judgment of the High Court. I will pass it on to the learned.
I'm representing the Group C and D untainted candidate. Counseling got over on 31st December 2018. Our appointments are much prior to that. We have been working since then, not for more than 6 years. We have not been named in any of the reports. The computer test was not even there for Group D. There is no case as against the appointees that they have done something to influence the selection or anything. In circumstances such as this Honorable Court has always held that the candidates who are innocent, who has not influenced the selection, can never be punished, Lord.
I was
NISA got
that for non-teachers, there was no post.
Yes, NISA was but tender process.
Non-teachers, but nobody was appointed beyond the 1 year period.
Yes, we are all within the panel, not these people, and if you are not,
May I make a submission on the? Milords, I'm on for the allegedly tainted group, Milords. Only 2 submissions on this. Repeatedly, the Honorable Court had put to the CBI to come forward with the metadata, which has not been done till date. Therefore, my lords ought to draw an adverse inference with respect thereto, at least at this juncture. If they were to produce it before the trial court, that then is for another day. But at this juncture, even on a preponderance of probability, my lords, there is no evidence before this court to even target a group as a tainted group. Secondly, the aspect with respect to hash value that my lords raised is very critical, because this is a classic, did the chicken or did the egg come first? Because there is no clarity in the 3 charge sheets filed by the CBI on which is the first scan. Where did Pankaj Bansal's copy, because they admit it's a copy, it cannot be an original. Where did it come from? And where and how did a data scan copy come up at a belated date? Without the provenance of a copy not being established, it is not just 4 conditions, my lords, but 6 conditions that 65B mandates. And 2 of those are in terms of the data having been created by a computer and identification of the device which created or stored it. Thereafter, the 4 conditions under 65B2 comes, which is with respect to how the computer output is made.
Yes. Lord, 3 respectful submissions. One, Lord, there is no answer to the delay. But this is very crucial because
understood that.
Yes. Lord, by statutory provision, OMR sheets were destroyed. That's little important. Now, Lord, the High Court records, Lord, at page 244, para 306, CBI stated that when it took possession of server of SSC, it did not find any OMR sheets in the database. Now, Lord, if SSC had no database whatsoever, how did Lord SSC compare the CBI Lord data with its own data to reach this conclusion? 1, 2, my lord. CBI also admits that they got 3 disks from Pankaj Bansal, but the data of OMR has come from data Centec, which was not covered by 65B Lord certificate. Now, if you have relied upon something which is not supported by 65B, is it evidentiary? Last but most important is this, my lord, and this is little unpleasant, but kindly permit me. Lord, the entire controversy started, as I said in my beginning, because of these rank jumpers. The petition was only in respect of them that after expiry of panel, you have appointed people. They were a small group of people. They have to go out, no difficulty. During the hearing of that, Lord Justice Gangopadhyay ordered CBI inquiry without any basis, without any prayer. Lord, your lordships have seen on record
Justice Gangopadhyay's interview, in which he speaks.
Now we have the data, we can't control.
No, not data. It is in that not learned judge gives an interview while hearing the matter, then joins politics. What the entire inquiry stated.
May I make a submission, Lordship?
Don't think your lordship.
I'm appearing for
Not hear this because it is unpalatable to the judiciary.
Why should I say? No, we've heard you, Mr. Dave. We've heard you on that. We are not going by that. What we are going by is the evidence. No, Mr. Dave, that's not unacceptable remark. I'm sorry. Complete. No, Mr. Dave. No, Mr. Dave. I'm sorry. No, Mr. Dave. We will not accept that.
Great disservice to the.
No, Mr. Dave. The proceedings have gone on absolutely dispassionately. We're going into the evidence. We are not going into any political issue. We have not allowed anybody to raise that.
How I entered in an important.
That's fine. But law in India, Mr. Dave, your experience, you also know the law in India, settled by Puranmal's case, is even evidence collected illegally is admissible in evidence.
Not on that.
That's all. That's all. That's all, Mr. Dave. No, Mr. Dave understood your argument. Next.
Your Lordship, I am for Group D employees. Group D employees, Your Lordships. We've got Commission's recommendation as well as the board's appointment order, and we are working. Now, the allegation against us is so-called expiry of panel. There's one argument which I'd just like to place for Your Lordships. 2F of the West Bengal Service Rules says panel means a duly published panel. So, what has happened in this case? On 28th of March 2019, the High Court had directed, that's at page 297 of Volume 3. The High Court has directed that a fresh publication of the panel should be made in compliance of rules. This order was passed on 20th of March 2019. Pursuant to this order, the panel was actually published with all the required details on 20th of June 2019. And that Your Lordship will find at page 3092 of Volume 2.
We have understood that.
And therefore, my only submission, Your Lordship, is number one, this is only on expiry of panel. This issue has been flagged by the High Court but not decided. It has nothing to do with the OMR issue. So, if Your Lordships, again we request that what does not pertain to the OMR issue and panel issue, either Your Lordships or some committee appointed by Your Lordships or the High Court should decide. And the issue is pending.
I appear for my lords.
We'll come back later.
Yes. My lords.
My lords, I am for the OMR. My lords, may I?
Okay, please.
My lords,
taking your time.
I'll be brief, my lords. I will stick to my time. I am for those with the OMR mismatch, my lords. My lords, when we do not demolish entire cities because some buildings are bad. What do we know today, my lords? We know today that there are rank jumpers, there are people who have been appointed outside of the panel. The SSC has said that and the West Bengal government has said that. And they, my lords, of course, cannot be part of the teaching contingent. But my lords, with regard to the OMR, the only evidence there is, and my lords, I have these notes here. The only evidence there is that of one accused.
Yeah, understood.
And my lords, the data scan text. My lords, at page 5, when I've opened the page, my lords, my lords, may I just complete this point? This point that Pankaj Bansal's own data is not matching with itself. It's at page 5, my lords. My lords, if I may just very quickly complete. It's a new point that has not been noted so far. My lords, it's at page 5. It is that the data sets recovered from Pankaj Bansal's possessions are OMR, DAT files, marks in a DBF file. It is important to remember that the DBF file recovered from him do not match the OMR sheets recovered from him according to the CBI charge sheet itself. Number one. Number two, the OMR sheets also do not match the marks in the file named so-and-so sent to Pankaj Bansal by one Atul Srivastava.
CBI
That's may I.
Is it correct that some OMR sheets were also recovered from Pankaj Bansal?
Yes, ma'am.
Pankaj Bansal recovered OMR sheets, data?
No.
The scanned version, ma'am. Scanned version of OMR sheets, my lords, and DBA files and DAT files.
Let's, may I just point
and they do not match each other. So how can we rely on Pankaj Bansal?
That's one paragraph which will clarify Your Lordship's doubt, which will
just the data was matching. Yeah. The Learned Council says that the data was not matching.
No, data is matching.
What is it that didn't match?
No, see, I just clarified to you. First of all, the data from the data scan take, the hash values, I will correct myself, the hash values do not change if the data is copied from one computer to another. So the hash value that we got from the data scan take matches with the hash value that was there in the Pankaj list. So the hash values match. The modification time, that means when the data was originally created, is also belonging to the 2017 period.
Find on data scan text computer.
Data scan text also is supported by 65.
What did you find there?
Data scan text
Data
because
scan
it came
text
as
is not
scanned copy.
Scan copies of the OMR.
Yes,
It's not supported by
those were
65
deleted-
email.
Those were deleted, but we recovered it.
You recovered.
Yes.
Subtenders, right, by nice.
All of them. All of it.
That is the commission of.
Okay.
Minutes.
Your time is over.
Para 305 minutes. Para 305.
Wait for.
3 short submission. Your lordships will today check insofar as the IFF of Group C and D untainted. If there is not even a single allegation against them, my lords, today on a doctrine of proportionality, I need to be protected. Well, there's one more.
Minutes, may I now? Minutes, may I now?
They had in the reply stated that there are documents, my lords, which show that even if not one of the OMRs were marks have been given. That in fact goes to show that the OMR are from Pankaj Bansal are accurate. They have not been interfered. What has been interfered with is the marks which have been taken.
Yes, yes.
Therefore, please treat that as sanitized and clean and act on that basis. That's why.
May I? Not sure. I've been waiting with it. May I? Take 5 minutes.
Complete
Please, Your Lordship, with only 5 minutes, I'll take 4 minutes first. This is a note. The first part, allow me, sir, please. The first part is 5 errors in the High Court. My main written submissions are page 92. Please refer to them, that Your Lordship, Your Lordship has seen them. Here are the 5 errors I have put. I don't want to read them, but segregation is the core. I am C and D untainted. Segregation is the core of the issue. Well, as we say segregation is possible because A, the allegations do not reveal any systemic flaw. Every irregularity, rank jumping, OMR mark mismatch, appointments after expiry of panel are after the fact of proper conduct of OMR, after the fact. Second, it is no one's case that the completed OMRs or its scans were manipulated. CBI's case is that manipulation is at the stage of data entry of the marks onto the server of the SSC, namely after the scanning and evaluation. This is very, very important. I've given the reference to CBI affidavit. The CBI has also filed an additional note on the last date, vouching for the authenticity of the scanned copies recovered from Pankaj Bansal in data scan. The CBI's investigation is complete, comprehensive. It was done under a Lordship's order of November 2023. They filed a charge sheet, free supplementary charge sheet. Other than those identified as beneficiaries, there is no challenge to the CBI's findings from untainted candidates or any of the state authorities. This is very important. CBI not only identified the accused, also all beneficiaries. It is CBI's position in their written submission that they are able and willing to provide details of individual candidates who received appointments. Then why not segregate? Why a blanket approach? Just 1 second, sir, let me finish. I've still got 1 minute left. Why should you not segregate? Because a blanket, one size fit all, has grave injustice. 1 minute more and I'm done with this. Next page. They have raised no valid ground against segregation. SST has failed to file an affidavit saying the number of valid appointments. Blank OMR sheets have been submitted by candidates, yet they've been appointed. SSC and state authorities destroyed the OMR sheets without creating a mirror image. I've given a page. I'm not going to save your lordship's time. I'm not going to any of the pages. Massive corruption on their part, costs of 500 crore, etc. Suggestion and re-examination be conducted only for those candidates who have previously participated. Because I am saying that the arguments against segregation are either non-arguments or illusory, and there is no valid argument given. Segregation does justice. A one size fits all is very, very dangerous.
When I did my opening argument, Lord, there is not a whisper on the other side with regard to any irregularity in the examination. Because your lordships have dealt with a large number of cases where the exam itself was about cheating, copying, SIM card going, etc. has happened. Here, there is nothing of the sort. Even today, they have not said that there is neither has the CBI said that anything was wrong with the examination. There is nothing wrong with the result also. What has happened is, Lord, that there is a original found outside, and what has been found in the SSC is different from what is in the original. That is how the premise is there. That this is original, this is the original mark which was taken on the basis of the exam, and what is in the SSC website is different from
what is the original Bansal. And those are the tainted, that's how the numbers have been identified by the CBI. Now, Lord, a very important question has arisen, and that is what is I feel also troubling the Lordships a little, that at the time of hearing before the High Court, the state authorities took a stand that there could be more. And that is something which is a little disturbing. I was also feeling how to answer that. Problem lies is very simple, Lord. For the state to admit that this much has happened is an admission that something wrong has happened. They could not, at least in the preliminary stages of the hearing. Now, of course, they have now taken a very clear, candid stand. But at the preliminary stages of hearing, to say that yes, this much has happened is an admission that yes, I have done something wrong. They could not have said that I have done something wrong. So they just wipe their hand off by saying that we don't know, we don't know. That we don't know doesn't mean not say one second. We don't know doesn't mean that we don't know doesn't mean just last one. We don't know doesn't mean that there could be other methods of wrongdoing.
But 2 seconds, I took 3 seconds earlier. Okay. 2 paragraphs, in total 5 seconds. 2 paragraphs, my lords, which will clear lordships all doubts about the authenticity of the data and the hash value. Please note those paragraphs, that's all. Para 305, 289, one more thing, just one more thing, just one more thing. In the concluding paragraphs, when you direct custodial interrogation of those tainted, how is it possible that you say that it cannot be segregated? We left our government jobs. The only prayer, as my learned colleague requested me to put it to my lords, was that do not cancel the selection was not the prayer. The second thing is we left government jobs to come to my lords. And the last thing, without taking more time, my lords, is that permit me written submissions to point out those paragraphs.
Just 2 points, my lords. Just 2 points. I represent untainted Group A and Group B teachers who've been teaching for the last 6 years. In our groups, the CBI has found only 8.5 and 14.4% to be tainted or irregular. What is the way forward for people like us who are a majority of these candidates who have been teaching in the state? The way forward is in Inderjeet Singh KHANNA, your lordships in 2006 said only if a majority of the candidates are tainted should you set aside the whole process. That is not the case here. Secondly, in Vanshika last year, your lordships sitting in 3 judges said very clearly that you must segregate because your response must be proportionate. If your response is to set aside the entire process, it is disproportionate and it is injustice to a majority of Group A and Group B teachers who have been teaching in the state.
Great. Couple of figures, Millard, I would like to point out, Millard. The total number of vacancies for class 9 and 10 was 12,905. The total number of vacancy as advertised in 11 and 12 were 5,712. The total applicant for 9 and 10 was 1,41,000 and odd, Millard, and for 11 and 12, Millard, was 1,50,000, Millard. There were first 2 writ petitions, Millard, that were filed. One is Setabuddin, Millard, and the other one is, Millard, Soma Sinha. Millard, the Soma Sinha was discontinued, Millard. Ours were the 3rd writ petition. We were the original whistleblowers, and Lordship will kindly take, Millard, one order passed in our matter, Millard, that would appear, Millard, at page 602 to 604 of our compilation, Millard.
Yes.
Here, Millard, a detailed order was passed, Millard, wherein, Millard, Lordship will kindly take. I'm sorry, Millard. 602 of Millard. This is volume 4, Millard. I'm sorry. Millard. Here, Millard, a detailed, Lordship will kindly take, Millard, internal page 2, Millard, where I'm sorry, Millard, volume 3, Millard. I'm sorry, I'm a bit confused with so many volumes, Millard. I have just made quick notes, Millard. I'm extremely sorry, Millard. Dr. Patro, Senior Counsel for the Commission, also files a report in the form of an affidavit wherein the manipulation of the marks in the OMR sheets of the above named candidates has been alleged. Let it also be kept on record. I'm reading from internal page 2 of that order, Millard, at page 603.
Please read it again.
Yes, Millard. Doctor will kindly take, Millard.
What is the date of this order?
This order is of 2nd of February 2023, Millard. This was the order, my lord. I may not, my lord, I will only point out the paragraph once, my lord. That is, my lord, Dr. Patrod, learned counsel for the commission, also files a report in the form of an affidavit wherein the manipulation of marks in the OMR sheet of the above named candidates has been alleged. Let it be kept on record. Thereafter, my lord, Dr. Patro submits that the recommendation of the above named candidate are erroneous, my lord. So there is an express admission with regard to that. Coming thereafter, my lord, on the basis of this order, my lord, there was a subsequent order that was passed, my lord, on 8th of February 2023, my lord.
Yes.
Page 605. These are here, my lord. On the 2nd of February's order was quoted on the very first paragraph, lordship will find. This quote, by the order dated 2nd of February, directed the commission to file an affidavit disclosing the to be adopted by the commission in exercise of the powers under Rule 17, my lord. Pausing here for a moment, my lord, what does Rule 17 speaks of, my lord? Rule 17,
Hello.
time and again, all my learned colleagues, my lord, have cited, my lord. Rule 17 empowers the commission, my lord, to, my lord, withhold on withdraw or rescind any recommendation that has been made, my lord. The power is vested exclusively with the commission. Now, my submission with this regard is the moment the commission exercises the power under 17, it sets the clock back to where it was originally. That is, my lord, at the time of 12.6, which my learned friend Miss Makija was referring to, my lord, with regard to publication of panel and etc. The moment, my lord, some of the people have been taken out where there is an express admission with regard to erroneous inclusion in the list and 17 is applied, my lord, we actually do a time travel, my lord. We actually go back and start the process afresh under 12.6, my lord. One more line, my lord. I have 40 seconds, my lord. I will conclude, my lord. For the period of 9 years, my lord, people who have applied and who are not called for verification, my lord, they would be inured to the benefit of their service period, my lord. They have lost everything, my lord. They tried, my lord, all ends up, my lord. They tried to get into the...
I have prepared a note. I have just prepared 1-page note. I just want to say one line. Lord, we are those who are working from 1999 and we were confined to one zone. Thereafter, we got an opportunity to go and to do it centralized posting. So we got centralized posting. We were selected. We are not in the tainted list and we got our pay scale the same as what was there before. Pay protection, provident fund protection, service protection. So everything was protected.
1 minute.
So therefore, my lord, I am only
division bench.
So my case is sui generis, my lord, in that sense, that it has nothing to do with the
division bench.
Much obliged.
This court, while remanding, told the High Court to assess, my lord, the admissibility of the scanned OMR. That's the principal question. The matter was referred to CFSL Kolkata. That's a part of the order which I read. Kolkata, my lord, after Hyderabad refused, went to Kolkata. Kolkata is still not examined. The High Court has still given a finding about, my lord, the admissibility, my lord, number one. Number two, the only other way, my lord, to find out of whether it is tampered, one is CFSL, the other is hash value. So if you have the original hash value, every time there is some tampering, the hash value changes. Right? But not here, unfortunately, original hash value was not taken. You don't get starting line, you can't go below to the next line. Therefore, my lord, the High Court committed a gross error in ultimately saying that we accept the certificate of Pankaj Bansal, notwithstanding 65B may not followed, but we rely on Section 3 and Section 58 of the Evidence Act to accept his OMR, notwithstanding, my lord, that Pankaj Bansal was nobody to keep, my lord, the hard disk. There is one more hard disk called Niladri Das, which has surfaced. There is one CD, my lord, which is missing. Untraceable. In the face of this is stated in the charge sheet. In the face of this, how do you, my lord, segregate one from the other? As far as I am concerned, this is not enough to knock out.
Your lordship may permit me. One point of the state.
Your lordship may permit me. Lordship.
Your Lordship may permit me for untainted candidates, my Lord. This is one page note, Your Lordship may have it. No, my note is here, my Lord.
Half a minute,
My Lord, my note is here. Just 1 minute. My note is here, my Lord. If Your Lordship may have it, my Lord.
Yes.
My submission is, my Lord, Your Lordship may accept the investigation that have been taken place till now as it is. We are untainted. We left the earlier employment and joined here, and through all the scrutiny, we are still untainted. My Lord, Your Lordship, just see page 1. There are 3 categories. I'll just quickly in 1 minute sum up this, my Lord. There are 3 categories according to me, my Lord. This is one is OMR mismatch. Second is rank jump and out of panel. And third is excess appointment. As far as first 2 categories are concerned, Your Lordship may see the box. In the first category, I have given all the paginations where this list is there. Your Lordship may turn the page. For the second category, the list is there. As far as the third category is concerned, which is excess appointment from the panel, this comes out of para 271 of the judgment. Now CBI or somebody has coined this excess appointment 1539. The list is not there. What is the basis? That is also not there. Now, Your Lordship may just read this with me, my Lord, this about this 1539 and 199. This is the source of this figure in para 271 of the impugned judgment of the Honorable Court. From the record, we do not find that the CBI has given the data or they have found excess appointment of teaching categories. CBI states that they will provide the details of individual candidates who received appointment illegally as mentioned in different tables set out in written submission, see para 12 of volume 6. All the appointees have recommendations subject to clarification by CBI. There is possibility that these sets of person may fall in earlier categories like OMR number mismatch, rank jump, out of panel. Hence, this number could be hypothetical. This is my submission, madam. Last one is, madam, that there is a portal of a state government. On that portal, all the details of all the appointed candidates are there. And there is no single appointment which is without recommendation of the commission. That's how I have been instructed.
Okay.
Last thing, my lord. Because we have left our appointments, my lord, earlier employment, my lord. We are in the middle of our ages, my lord. We have children, my lord. Your lordship may apply the principle of segregation and protect those who are untainted and innocent.
Yes, please.
Lordship, most important point I have to bring on the record. Lordship, the main petitioner, BAISHAKHI BHATTACHARYYA, she is at now 54. She is not bona fide candidate. She is now at 54 age. At the time of examination, she was 40.
Just 30 seconds.
Lordship, and other my points are given in there.
Okay, fine.
And details.
No, I'll give you 2 judgments here where my lords have held, without this court has laid down, that in the case there are 2 categories, illegal appointed and not properly appointed, then if there is a possibility of segregation.
Slightly away, please.
There is. I have only one sentence. I have
one sentence. Integrity of the process we come back to as the basic question, Lords. 3 judges bench in Anwar's case.
I have one sentence, my lord. There is one side is the dishonest candidates, other side the honest candidates, and there is SSC and the state. As one line short, so that the innocent honest candidates, they do not lose.
Okay, fine.
They are in the system.
Just 30 seconds.
Sometimes, I'm in the category of the untainted, and we say that we should be segregated, which I therefore adopt the arguments of Dr. Singhvi and others. Just one thing, I'm just handing over a note. There are at least, according to our calculations, 20,000 people who appeared, who have given up their jobs, etc., and come in. And for instance, clerical staff, assistant teacher.
Now only the state council.
Yes. I just want to say one thing, my lord. I am appearing for just 30 seconds only.
I am appearing.
I beg to
May I just point out?
We will not be able to.
Just 30 seconds only.
May I just point out the things, submissions which have been made by the CBI
are totally contrary to the records. Malad, today, for the first time, the CBI has handed over and said, following the inspection, no candidate disputed the authenticity OMR images shown to them, asserting that they are not theirs. Now, specifically, there is a affidavit to that effect. Malad, kindly comes to page 656. Well, yeah, just 10 seconds. Just 10 seconds.
Give me just one line.
Just 10 seconds. Their admissions are just 10 seconds. If I just kindly point out the affidavit, Malad.
Please sit up. We have audio.
May I show only one paragraph, man? Only one paragraph. How did we reach to the authenticity? Right? Only one paragraph.
Please, we have gone through. We have heard you.
Not just 10 seconds.
One line.
Just 10 seconds.
That's all.
Just 10 seconds. But I beg to appear for the waitlisted candidates. But there is an issue as far as appointment of these waitlisted candidates to supernumerary posts is concerned, which is pending in the High Court, my lord. And that writ petition, my lord, is 25056. And ultimately, my lord, just one more thing, my lord.
Lord, may I point out a logical infirmity in the judge's in the impugned order. Lord, paragraph 240. Lord, the judge, the division bench segregates and says these are unduly high percentages. Lord, segregation is by perforce possible. Lord, I would urge your lordship to make.
Permit me one sentence.
No,
Please permit
That's
one
all.
sentence.
That's all.
I promise I will not repeat what has been stated. There are 3 hard disks. The first one, there is no hash value. And the entire data which Pankaj Bansal and Scantech, which has been come out and they're talking about being genuine, is from that hard disk, which there is no hash value. Even in the 65-bit, there are 285. The first one does not have a hash value. And the entire data, it like comes out of a PC circuit, magic show, the entire thing comes out and says, yes, Pankaj Bansal data is correct, so is Scantech. That the entire thing comes out from one hard disk, which does not have a hash value. That's it.
May I just add one line? May I just add one line?
Can I gains that's over?
One submission.
We have to bring it over.
One submission will not
We have to
behalf of one submission will not kindly consider.
No more, please. That's all.
Kindly have first page 161.
I could record that
Yes, please.
there is a clear data. One.
That's all, please.
Well, one line can add. Leader may be just unmuted for a minute. He wants to make one submission on our behalf in item 4. I'm appearing for 18 blind teachers, my lord, and they were already in service. They took these exams for promotion. They're in the untainted lot. They're 18 blind teachers. One of them has been given benefit by the High Court at paras 360 to 362. We're asking for parity of treatment with that person with disability. These are 18 blind teachers who are already in service.
Why did you not ask the High Court itself for the same belief?
Malaj, we were not made parties. We were not aware. We were not aware. We were not parties, my lords. That's how we did not realize that our appointments are going to get cancelled. And lordship, the retention period of 1 year, I just want to show pages 355 and 376 of volume 5. It is the standard practice for the retention period only to be of 1 year. So nothing that SSC was doing was uncommon. Secondly, if we may be given a chance to show subject by segregation.
No, that's not possible.
That's
not possible. So that's all, please. Yes, Mr. Devi. Mr. Muridhar,
yes,
give us the names of those 18 candidates.
I'll do that. I'll do that.
We are aware of that argument, Mr. Bala, we are aware of that argument.
I just
Yes, Mr. Reddy, that's right.
just one submission for the government council. The submission is essentially this, that your lordships, having heard the state council now and the state agencies, it's quite possible to go ahead with segregation. Now, if that is the case, my lords, on a principle, proportionality was canvassed. Just consider the situation of persons in service for 7 years, 10,000 teachers untainted whom I represent. So I would urge your lordships, balancing. I think it's possibly a duty for constitutional court that where segregation is possible to apply that rule. Unless it's completely impossible. It appears here to be possible.
While adopting Mr. Divan's argument,
please, no more. That's it. No more.
Yes, Vijay, Lordship put one question to the state to answer. That was regarding the observation in the High Court judgment that there is widespread
state has accepted that there is widespread. I only say this, Lord, that there have been irregularities, but there's no difficulty on that, Lord. We accept that position, but widespread only means, Lord, that 50% and 6 virtually faults were found, Lord, with regard to Group C and Group D, Lord, by Justice Barnes Committee by that time, Lord, and 10%, Lord, as the Lordship saw the percentages. So therefore, what we mean by accepting widespread, Lord, is that only, nothing more than that. It doesn't mean, Lord, that there is something more.
Argument, sir, judgment reserved.
No, there's one. The point that's written.
Accept our written notes now.
There's this one. Because I have something else.
And for the
The point which your lordship reserved for me, Lord, is regarding entirely different. That is regarding CBI investigation, which your lordship said I'll hear later on.
That point which they take.
our written notes are submitted.
That is with regard to the supernumerary force.
The order which we passed, which expressly mentions at page 368 that it is subject to the orders passed by the High Court. Number one. Number two, Lord, there is in the petitions which have been decided, none of the petitions challenge the government order. Number three, Lord, there is another petition pending, which is petition 25056 of 22, where, Lord, specifically this order was challenged and it was stayed. So no appointment has been made, Lord, pursuant to that government order. The next aspect is, Lord, that the reason for issuing the order was that since, Lord, certain infirmities had been found, therefore, Lord, we said that subject to the orders passed by the High Court, from the wait list, it doesn't say illegal. The order says at page 368 that from the wait list, Lord, will be appointing, Lord, because there are so many large number of teachers were going out, Lord. If all of them go out, Lord, the whole education system will fall there. So therefore, Lord, we left it to the High Court that if not something which is found, we can account.
That's my point also, my lord. We have exams. We have exams which end. We have exams which end in April. Results come in May, my lord. Your lordship,
The submissions